Group 6 matter, Your Lordship.
Have you served notice?
Lord, may I permit to mention one restoration application for inclusion in
My lord, corrections. Ija. And indicated the date of order. My lord, yes, correction. Yes, yes. And these orders have not been uploaded. That my lord was yes.
not uploaded. Minor one application.
Record. Afternoon. Let the matter be placed before the concerned honorable bench at Jalpaiguri Circuit Bench. The instant appeal has been filed with a delay of 27 days. Without an application to have been filed for condonation of the same. The department is directed to transmit the case records of the instant appeal to the circuit bench of this court at Jalpaiguri. Next.
Amount, my lord,
Amount and the
71,699. And my lord, respondent number, paragraph 10,
2 has become respondent number 1.
224.
2 to 4?
One already paid, my lord, another is paid. And my lord, post title, my lord, Dhada, not Dhaba.
What to do, sir? I mean, in every matter, this is happening.
My lord, what is this parent?
Next.
No, I am more the respondent, my lord.
I appear on behalf of the petitioner, my lord. The senior citizen suffering from retrial benefit. Retrial benefit has been denied. We have initiated a first round of litigations. We have got our pension.
Where is the affidavit in reply?
Affidavit in reply to the affidavit in reply to that. Kindly pass it over for a while, my lord. I'll take care of it. Affidavit in reply is ready. There is. Copy আছে আমাদের? My lord, may I have it? This is copy, please.
You said that you have already received the copy.
My lord.
Yes.
Lordship, the thing is this, my lord, the first round of litigations has been initiated by the petitioner before your lordships for pension and retrial benefit. There the dispute was whether it is a voluntary retirement or a voluntary vacations. According to my learned friend's client, my lord, it is a voluntary vacation. But I could not attend my service at the time when they called for, because of some reasons, because of medical reasons. I have assigned all these papers, documents for medical reports and everything. But still they have come into conclusions that I have voluntarily vacated the service. But my content,
How long were you on leave?
my lord,
How long you did not attend to the services?
my lord, for a year perhaps. But my reasons was that I made an application for voluntary retirement, and such application was admitted, and then I absent from the service. But they are saying no, that application is not the voluntary. I mean the voluntary application for voluntary retirement. We did not accept such applications. We appealed. Then they come up with reasons by saying that no, our rule says you have to complete the pensionable service for 20 years and etc. Then we come down and says that these are the rules and these are the provisions in the rules, that even if, irrespective of the age, we are entitled if we qualify the 20 years of practice pensionable service, and we qualified the 20 years of pensionable service. Then the dispute arose, and they did not honor my request and did not release my pension, retrial benefit, etc. Then I and then I approached before the Honorable High Court in the year 2009. My lord, thereafter, the approach and the and the order passed by the the Honorable Single Judge, allowing me for the retirement and allowing me for pension. Then they prefer appeal, and the appeal court affirmed the trial court's order. My lord, then did not pay the pensionary benefit. Then I come up with a contempt application. In the contempt application, my lord, they have released all the pensionary benefit and etc. But still, my lord, some pensionary benefits are yet to be released. For that, my lord, we obtained the leave from the contempt court and filed these writ applications. These are some and substance behind these writ applications.
How much have they paid you?
That it is around 25 lakhs.
And according to you, what is the remaining to be
Remaining, my lord, the
disbursed?
calculation is there, my lord. My lord, if I may allow to place before your lordships, before I go into the calculations and all, if I may allow to place before your lordships the division bench order, my lord, at page 50, at page 239 of your lordships, please. Page gulo bole. This is the detailed order, my lord, where the rules has been considered and why their contentions has been overruled. It's a long 6 pages order, my lord. If I may allow to.
You come to page 243.
243, correct. Lordship. It's a internal page.
OSR 43 does not mandate report for duty as a precondition. In event the employee does not report for duty in the stipulated period, he may be deemed to have voluntarily vacated his service.
Lordship.
Clearly, the bank pursued a line with otherwise non-application of mine regarding respondent's situation. That did call for interference, and we confirmed the setting aside of the order of the bank by said letter dated such and such. To give respondent the relief it was required to be set aside.
Lordship.
No ground was taken in the memorandum of the letter not having been impugned in the writ petition. There will be orders in terms of prayer B and C. So far as interest on the Provident Fund is concerned, the bank will pay interest at current rate payable on the savings account. The interest on gratuity is to be paid at statutory rate for the period applicable.
The next paragraph, my lord. The bank will also pay respondent
Okay, okay.
pension or inform him.
अरे बदले ये
Go,
कोई नहीं
go.
जानता
Hey, I'm sorry, I'm sorry.
अरे ask So we will continue with this on the next date. Your
Your Lordship, kindly fix up on Monday, my lord. Your Lordship, the writ petitioner before your Lordship is
been extra proactive, sir.
Lordship.
If you realized that he has been a
I
Chanchal.
extended apology, my lord. Kindly consider.
Kindly do not fix on 18, my lord.
এটা কি কোথা থেকে চলে এসছে দাদা?
This.
Yes, sir.
Kindly do not fix 18th of the auspicious month. 18th of this month. Accepting.
Affidavit and reply filed by the learned advocate representing the petitioner be kept on record. Heard the submission of learned advocate representing the petitioner. The learned advocate representing the respondent bank
My lord.
is present. Next date be fixed on 25th of August.
I'm good.
For my lord, I have for
I'm taking time to file a written notes of submission argument.
You have it with you?
Both
Well,
the parties.
because of fever, my lord, I could not do it. I'm taking 1 or 2 days time, my lord.
Because the list of dates have been filed, but the written notes of argument are to be filed. Lordship, I'm just paying for extension of time to file that. Lordship.
You were given 3 months time.
I know, Lordship. I was in 3 months have been very difficult for me. I know that.
Chanchal. 1 week as last chance.
1 week, Lordship. Deeply obliged.
On the prayer of the learned advocate representing both the parties. Next date be fixed on 12th of August for filing written notes.
May it please your lordship, my lord. On previous occasion, we have submitted
I am for the
factual
respondents.
Today we will submit, my lord, the legal proposition, my lord. But today, my lord, I am not in a position to do the matter. My lord, kindly fix it in the next week, my lord, because by this time, my lord,
My lord, last date I have filed my written notes of argument. Today I have handed over a copy to my learned friend.
Sure.
today your lordship was kind enough to heard us also today.
Huh?
My lord, today.
Tell me.
Your
I didn't hear you.
Only, my lord, today your lordship has heard the matter, and thereafter, my lord, the matter has been, my lord.
No.
You were not there on the earlier occasion.
Yes, that was the day, my lord, that the traffic congestion was there on the 21st of July.
You didn't come to court due to
No.
traffic congestion.
No, my lord.
Are you?
No, I have not, my lord. But this is a one kind of holiday, my lord, for us.
So come to the point. The way you are enjoying holiday. Last chance, which date?
Any date convenient to your lordship, my lord.
19th of August.
My lord.
19th of August. On the prayer of learned advocate representing both the parties, said the matter be fixed on 19th of August as last chance.
My lord, I have handed over a copy of the written notes of argument.
On that day, my lord, I will file my written.
It is for him to go through. Next.
I am grateful.
I am very for the
Number 6 to 8, Mrs. Sushmita Sahadostu is appearing now for the CIC. Or kindly fix it at 58.
Either she is absent or she's not there in court on time.
Personal reason, my lord.
This is something I've been facing for the last 1 year, sir, as far as her matters are concerned.
I'm not aware of that. My lord, kindly-
You are aware of. Have other matters also to do. It cannot be the
Paper book was given, my lord.
what paper book in a writ petition.
Documents. This is the date for hearing. I mean, this is the
But I'm suffering from cold and fever. I have come so that matters can be concluded.
Sir, there is live streaming going on. Don't make me say anything. I'll fix it on 26th August as last chance. Whether
Fine.
she appears, she doesn't,
My lord.
you
Well,
will complete.
my lord.
I mean,
আমার নামটা দিয়ে দেবে
how many dates has she taken? And this is not in this particular matter.
My lord.
In all the matters where she appears, she has a junior. The junior at least can get himself prepared. One Niladri Shaha is her junior,
My lord.
right?
My lord. My lord.
That junior can also be conversant with the facts and circumstances of the
Right.
case, and at least next
Oh, sorry.
26 August bolna to
তাহলে আমার নামটা কি হবে
respondents again. ওরা এমার্জেন্সিতে পৌঁছে গেছে।
আমার নামটা লিখে দাও
My 9, this is my application. I come before your lordship for against that charge sheet, crossing of a charge sheet is a case of a disciplinary proceeding. My lord, disciplinary proceeding was initiated without, my lord, any independent witness, without any independent witness behind the back, while I am is admitted to the hospital that time. My lord, disciplinary
You
proceeding.
did not participate in the
Yes, my lord, I have participated. I am given a reply. I have given, my lord, to cross-examine the one of the witness that has been that has not been accepted. And my lord, the wholly the total my lord, the proceeding is based on the, my lord, relative witness, not a independent witness was adduced. The fact is that the person concerned, B. Deka, was, my lord, called me to provide some loan. I went up there. Thereafter, at the time, when I was going, I met with an accident. I admitted to the hospital. Thereafter, I have been, my lord, shifted to the Chittaranjan Medical. And when I came up my house, that time I came to know that disciplinary proceeding was initiated against me. I challenged that my lord, against that order. I prepared an appeal. That order in an appellate forum, that order was upheld. Against that appellate order, my lord, I came before your lordship. And when that matter was came up, the honorable judge, my lord, admitted this application and directed them to give a opposition, and reply was given, my lord, and the matter was ready for hearing, my lord. And the fact is that, my lord, I was joined in a service in 1985 as a, my lord, CISF constable. Thereafter, my lord, 16/3/2008, I was admitted to Mejia Power Station Hospital. Thereafter, 21/3/2008, I have been discharged from Mejia Hospital with the advice to take rest up to 30 March 2008. Thereafter, my lord, the person concerned, the BDK, was requested to provide me some loan. And my lord, upon acting upon his request, I went up there. And while I am going, that time I met with an accident. And thereafter, my lord, I admitted to the hospital, and subsequently I have been referred to the Chittaranjan, the Advanced Medical Institute. And while, my lord, I have been discharged 9/4/2008 from hospital, I came to know that while, my lord, I was in a hospital, the conducted a preliminary against me without giving a notice. The preliminary inquiry was conducted against me without giving a notice, my lord. Thereafter, my lord, subsequently acting upon the preliminary inquiry, my lord, 6/5/2008, memo of charge sheet was memorandum of charge was framed against me, and I have given a reply. They have not acted against my reply, and they initiated a departmental proceeding against me. I participated on that proceeding. I raised a specific point that I want to, my lord, cross-examine one of his witness, but they was not, and not only that, they had not provided the relevant document. At that time, where I am seeking that what kind of a documents they are relying to against me to proceed with the disciplinary case. It is my right, my lord. That time, my lord, I have written that, but they have not provided me that the relevant document. The what kind of a document they are relying upon. And total, my lord, disciplinary proceeding is a malicious proceeding because they are not relying upon a independent witness. They are, my lord, acting upon the relative witness, and the, my lord, impugned, my lord, punishment was drawn up against me. Against that punishment, I preferred an appeal. And, my lord, appellate forum also, my lord, upheld that order. And against that, my lord, I came before your lordship.
Affidavit in opposition, if it is on record, then it is ready for hearing. Kindly grant us time to file if it is on record. Otherwise, we'll have to reaffirm it.
এটা আছে?
Affidavit in opposition, if I'm watching.
Yes, you are representing respondent number 1 to 4.
Yes, yes.
It's on record.
Then we'll consider a fix the time. Very grave charges against him.
Grave charges.
Yes, ma'am. Kindly see possibly page.
My lord, abusive what? Say, they have, my lord, sexual activities, but that has not been evidence. Medical evidence was not.
Yes. Placed his case twice. I will just
ठीक है,
place the
बोलो ना।
charge sheet. Charge sheet page 11. Charge sheet has been set out by the petitioner, my lord.
Sir, we are running 1 hour.
Yes, yes. No, very grave charges. He
Yeah, I've seen molestation and all.
yes.
And if, my lord, molestation, they have to provide me the medical document also, but that has to be substantiated by the medical document. What kind of a medical? Let them produce the medical
parallel
document.
Criminal case was instituted against him.
No. And, my lord, kindly directed them to produce the medical document. What kind of a medical document to provoke him to institute a charge against me? Because they are using the word that sexual activities, but that has to be
Heard the
substantiated by
submission of learned
medical
advocate
document.
representing the petitioner as well as the respondents. Next date we fixed on 27th of August.
And, my lord, one in a
Liberty to
prayer,
file
my lord,
notes of argument.
and direct them to produce the medical document, my lord, also.
What medical document does he
Because
want?
they are using the word sexual
Let
activity.
him file an application if he wants
No,
any
my lord, that
document
is
from us.
my lord who has
There
the
has
power.
to be some procedure
You
followed.
file a list of
Let-
dates.
I shall file a discharge, my lord. Case record also be, my lord, produced before you. My lord, kindly directed me. Otherwise, they shall not produce.
Which medical report?
Yes, my
My
lord, case
medical
record
report.
shall be
Advocate.
produced.
My medical report he wants. What?
No,
So
তোমার medical কেন?
agitated.
Car chao.
আর মেডিকেল চাইছো
Medical documents, so far, my lord, the case record, my lord, in a disciplinary proceeding, the
The
case
learned
record shall be
advocate
produced before,
representing
my
the
lord.
respondent. Sir, you are which department?
CSF.
CISF.
Yes, ma'am.
CISF is to place the case records of the disciplinary proceedings pertaining to the petitioner. On the next date of hearing. Next.
পেন আই
হ্যাঁ।
আমার সাথে
আর তোমার সঙ্গে কোথায় লেগেছি? তোমার সঙ্গে লাগতে পারি আমি?
For the Calcutta State Traffic Corporation.
Yes, yes. Now you give chance to others.
And I am for the petitioner. Now, the petitioner
No, I'm for the respondent.
was censored.
Sorry.
The petitioner was censored following a departmental proceedings. But that is not subject matter of challenge or subject matter of mine. There is no grievance. Yes, they have censored me following a departmental proceedings. My grievance is that for the punishment of censure, my increment has been withheld and my career advance scheme, benefits under career advance scheme were deferred for 3 years. There is no law, my lord. What are the charges against me? The charges are, my lord, I am a conductor.
Is there any rule that
Yes, I also.
censure will entail any kind of punishment?
I also. Regulation 36. Now, my lord, my charge, you will also kindly come to the charge sheet. That is, my lord, at page 17 P2.
Page?
Page 17, annexure P2, my lord. There are two charges. Now, this is written sorry, my lord, this is written represented against the charge sheet. Page 16. Page 16, my lord, the charges. There are two charges: keeping unbooked one long journey passenger. I am a conductor, my lord, who was penalized with a fine of rupees such and such, keeping unbooked a gang of 3 long journey passengers, which total fare amount to 42. Now, these charges are minor offences as per regulation 36A. And for minor offences, the only punishment is censure or withholding of increment for 3 months. Now, my lord, my increment was not given for that year, for the whole year, and my career advance scheme was deferred for 3 years. There is no rule. This is minor offense. 36 deals with the penalties, and 36A was amended, will inserted. I will show you, lordship. 36A, regulation 36.
আমাদের এখানে CISF rules আছে. Is it CISF or BSF?
Yes,
Oh.
yes,
CS? Oh.
yes, yes. Calcutta State
CS
Transport
is
Corporation. Yes. What is 36?
You have a copy of the rules?
That is.
Yes, it is.
No, it is a no. CS Calcutta State Transport Corporation. Yes. 36 8 hour ko. 36 8 hour ko. Are 8 na.
Amendment.
Page
36A.
what is the penalty?
Now, how do you define a minor offense and a major offense?
See the rule, come to the rule 36(1), censure. The following penalties may for good and sufficient reason
36?
and as hereafter provided be imposed upon employees of the corporation. The censure, withholding of increments, reduction to a lower post, recovery from pay of the
No, you have just
36
placed.
below 36A has been the 36 has been amended and 36 capital A has been inserted.
I have asked as to what is the definition of minor offense?
Yes,
You have
that's a
given a
definition. There is a definition under regulation 39A. Your lordship, kindly have a look.
maybe
That minor offense shall mean and include. Bottom middle of page 13. They have not amended. 39A, that minor offense shall mean and include short or excess collection detected during backchecking of a conductor between rupees 2 to rupees 5 in city routes and between rupees 2 to rupees 7 in long distance service routes. The cases where unbooked passengers are detected by the checking staff up to 10 passengers in
Where are you reading, sir?
39 capital 11, page 13.
Page 13.
Page 13.
39A.
Minor offense and major offense have been defined.
Yes.
Lordship
So
has
they
got
put
it.
you under this.
39 capital A.
The charge
Correct
states so.
Yes, according to the regulation 39A, up to 5 passengers detected unbooked are to become under the purview of minor offense. You lordship, kindly 39AB. The cases where unbooked passengers are detected by the checking staff up to 10 passengers in city routes and up to number of 5. Here, when 4 passengers were detected unbooked.
punishment has been accepted. It is not under challenge. Why you are
No,
saying
I am challenging the withholding of increments. How can I withhold? Under what law you have withhold my increment? Your lordship has got 39A.
Yes, what about 3
Now
months? Where is
36.
it?
36.
3 months?
3 months.
We said 3 months increments would be withhold.
have been with 3 months, 3 years career advance scheme has been withheld.
What
And-
does the law say?
Lordship,
Regulation কি বলছে?
regulation is saying, my lord, that is a minor offense, and minor for punishment of a minor offense, the only punishment is censure or, my lord, withholding of increments for 3 months.
Where is it?
Yes, I also, your lordship. So,
Censure and withhold 6 months, 36A.
6 months, 6 months, 36 capital A.
Penalty for a minor offense shall include censure
Yes,
and withholding of increments up to a period of 6 months.
lordship, I have been censored. I have no objection. I have been censored. That is a minor offense. Punishment. But how, my lord, my increment have been withheld
For how long?
for the whole year?
Sir, it's
Your
not
lordship, kindly, I
censure
will-
or, sir, it says shall include censure and withholding.
Yes.
It's not censure or.
Yes, and
So,
3 months,
and-
6 months. That is,
And up to a period of 6 months.
now I've been with my increment I mean, for more than a year. I have not got that increment in my service life. Now your lordship kindly come to my representation, page 20. I have
Page,
page 20, P4. In the said final order, there was no order as to withholding of reduction of increments or wages. In spite of the fact the depot authority stopped to allow my normal increment for the respective year, which is unlawful.
yes. Now, what was their reply?
They have not replied.
You have not replied.
No,
He made an application for review before the managing director. That was rejected. Lordship,
why is my application
and my lord,
representation?
Where have you mentioned that? Sir,
Departmental
let him
proceedings, my lord.
submit.
he in the departmental procedure, he participated, he gave a reply. And my lord,
He is not contradicting or confronting the disciplinary proceedings.
Yes,
He has accepted the fate.
yes.
He is stating that instead of 6 months increment being withheld, you have proceeded to withhold the increments for a year. And subsequently, you have not granted him the
Career.
benefits of
Lord.
CAS, isn't it?
Yes, yes.
no, my lord,
Then-
it's not at all correct, my lord. Under RUPA 1990, his pay was correctly fixed, my lord, and incremental benefits have
But
been
sir,
given.
whatever it is, sir, you
I
must
said, my
have
lord,
given
in
him
my
a
individual
reply.
position, but
You must have given him a reply to this letter, to this representation.
has not annexed to this.
You know, they are
management petition.
affidavit in opposition, your lordship. They have admitted
have-
that.
No.
Where?
Lordship, kindly come to page 11 at
Page
Annexure
10,
R1 to the
just a minute,
affidavit in
page
opposition.
10 of their
Page
affidavit in page,
Page 5, paragraph
page
10.
Annexure
5,
R1.
paragraph 10 of their affidavit in also.
Paragraph?
Paragraph 10, my lord.
This
The
representation
petitioner
was
knows
not, my lord,
very well that
annexed
the
to the
benefit under career advance scheme would not be given to him on completion of first to 10 years of service as a disciplinary initiated against him was pending for disposal.
following the rules.
Thereafter, my lord, thereafter.
No, it was culminated
In the
on
final order,
24. So once it was culminated,
yes.
then what?
Now, my lord,
Well,
Then
as
to
per
you would
yes.
give
my
effect.
lord,
That is my grievance.
benefit of
Maybe during the pendency,
yes,
you had withheld.
Yes.
that was deferred, and but he has been given that,
He has been
After
given.
3
He
years,
has
my
been
lord, after
given the
3
benefit.
years.
and he has admitted
Under
his
ho-
petition.
So why have you come for that differential amount?
Yes, and for
No,
the
no.
increment, my lord, I lost, my lord,
Increment
during
has been given.
that period.
All incremental benefits
No,
have
no,
been
no,
given.
for one increment was
Now,
never
the,
given.
the rule says that following the promotional rules, the benefit under the career advancement scheme is given.
Where is it?
My lord, lordship, can I say?
It
In
is-
case of,
You have annexed that document.
no, I have referred it in the affidavit in opposition.
But you should, it is
3 years.
order, whether
yes.
you have granted him or not.
My lord, no, I have given it after the, my lord, period of departmental proceedings. That
Fair
is
enough, but
because of-
it should be through a communication,
Yes, my lord,
through an order. Where is that?
my lord, it will appear from the service records, my lord. He has admitted the position.
What
In the
had been
written
said.
letter.
Write it in the service records that I have given him such and such
No, Lordship,
without issuing a
Even a-
formal order.
Lordship only we can come to the pleadings of the
Sir, you
petitioner.
please seek clarification. There must be an order. If you had at all granted him,
affidavit in opposition is totally silent about that, totally silent.
if you had given him that benefit, it must be there on record.
I am on the verge of retirement, Milord. Now, Milord, I will create-
So you instantly want that order to be dictated?
No.
So let
I-
him first.
Yes. I want Milord dispose.
Please.
I want disposal of my representation.
Lord,
Page
we
20.
propose for giving the
At
benefit
this stage, Milord, I
under
want.
the career advancement scheme. The audit my lord observed that he was not entitled to that
Right.
benefit at that time because of pendency of the proceeding. And that has been given later on.
That can be understood, sir, that you had not disbursed during the pendency of the disciplinary proceedings.
Yes.
What about afterwards?
Well, he has been given.
That's what I'm asking you, sir. When did you give him?
Well, I have mentioned my lord in my affidavit in opposition.
So where is the copy of that order? You must have issued an order.
No,
Verbally, you had given him.
my lord, in the service books, my lord, it is entered.
So
Whatever
there is
increment
without any
benefit-
formal order being issued.
No. It is not a procedure, my lord, to be followed.
Fair
for
enough,
giving
sir. You
incremental
file
or
an
other
affidavit to
benefit,
that effect that
all
it
my
appears
lordship,
in
my lord,
his
recorded in the
Wait,
service-
sir. You file an affidavit that after the conclusion of the disciplinary proceedings, you had disbursed his claim, which has been entered into the service records,
my lord, I have-
annexing a copy of the
At this
service
stage, I will
records.
pay to your
I have-
lordship.
I have
Just a minute.
mentioned
Just a minute. At this
in
stage,
my
I will pay to
affidavit.
your lordship. Let them dispose of my representation dated
Which one?
1/4/2006
Have you annexed to the
and
representation?
disposal. Yes, page 20.
That
Page
was
20.
rejected.
It was rejected.
No, it was
You have a copy of it.
The review petition, so.
that is the prayer for allowing normal increment and CS. Page 20. Yes, that is that.
Don't tell us.
Well, lots of kindly come to my lord. One
I mean, representation.
ঠিক আছে, আলাদা না, Up to page 11 of the affidavit in opposition, annexure R1.
Sir, it seems that you are more interested in prolonging the entire. The records that they had given it to you,
No.
then what else remains?
My increment was never given for that year.
So let them come up with their
No,
statement.
I am just
Let them
praying to you, Lord, let them decide. Let them dispose of my representation, dispose of the writ petition. That is my simple innocuous prayer, my lord. Let them dispose of my representation dated, my lord, 1/7/2006, page 20, annexure P4. There is no necessity to keep the writ petition pending, my lord. They have not replied to that.
No, you have not replied to this representation, sir. First off, is it July or April?
It is, must be, my lord, July. No, they have, must be April, my lord, because they have received on 1st April 2006. They received.
The lordship kindly come to page 11, annexure R1 to the affidavit in opposition.
এত সময় দেওয়া যাবে না।
That is the appeal, my lord. That is the appeal.
Page 9.
Yeah, that is the appeal, departmental appeal. By one word, you have disposed of that.
Same points were taken.
They
that
heard the submission of learned
What you are
advocate
submitting,
representing
Mr.
the
Perry?
petitioner as well as
Actually.
the respondent. The learned
The
advocate
appeal.
representing the respondent is to file an affidavit stating that after conclusion of the disciplinary proceedings instituted against the petitioner, the benefits with regard to
Career
CAS
advancement scheme.
had been disbursed in favor of the petitioner, which had been recorded in his service book. A copy of the service book, which stated that the petitioner had received the career advancement scheme benefits
After 3 years.
The completion of the
after the completion of the disciplinary proceeding is to be annexed. Next date we fixed on 26th of August.
Yes.
Next.
Let them file a supplementary affidavit, my lord, showing that all
That
the
stated that, sir.
May I take back the reports now?
You know, the
I am appealing for the petition.
yes.
I'm for the state, my lord.
Before my learned friend starts, I am taking a preliminary point. Although my lord, I have been engaged my lord, just my lord, 1 week ago. That my lord, earlier occasion my lord, challenging the selection process in the judgeship of Malda, a writ application has been filed. That writ application has been disposed of. Now my lord, what I find from the instruction my lord, that has not been
Who are you representing?
District Judge Malda.
When were you appointed?
I appointed July,
When were you appointed?
4th July.
Who has filed the wakalatnama?
My junior.
Was there any direction for filing affidavit in opposition?
Affidavits, everything complete.
It's complete.
At
Now
the
tell me
last
what is
stage-
the issue?
Issue is, my lord, the post of Bengali translator can be filled up from 2 channels. First is from amongst the upper division clerks, that is by promotion. Second is through direct recruitment. Now, my lord, I was appointed by a very recent order from upper division clerk to the post of Sheriffsadar, and there was a contention to that effect that if at all subsequently any recruitment process is initiated, my appointment to Sheriffsadar may be cancelled, but I will be given a grade 2 post. Now, at that relevant point of time, one advertisement was issued, my lord, requiring, my lord, candidatures from only scheduled caste candidates in respect of 1 post of Bengali translator. That would amount to 100% reservation. That my lord, debarred me from participation. Second is that,
Did they follow that 100-point roster?
yes, but the point is that that was only 1 post that was reserved for scheduled caste, and the, my lord, criteria which they had laid down was only in respect of English, my lord, graduate in English. Now, but at that relevant point of time, I had approached this honorable court challenging the advertisement, and subsequently what had happened is that a submission was made before the honorable court. After the matter was served, subsequent to the service, they have passed an order saying that my appointment has been cancelled. Now, subsequently, that writ petition, I was not able to get an interim order in that writ petition. Subsequently, that writ petition was disposed of by giving me liberty to challenge this particular proceedings, which learned senior friend doesn't have the instructions. He's not having the instruction. That is why he's taking the preliminary point, which is totally not applicable. Now, my lord, here before your lordship, my lord, the order by which my previous order was cancelled, my appointment to the post of Sheriffsadar was cancelled on a misconceived notion that, my lord, I was junior in rank in respect in the gradation list. That is the contention while cancelling my lord appointment. My contention before your lordship today would be, as of today, my lord, there has been an appointment. One particular person has joined. He is also a private respondent before a lordship. My contention today before a lordship would be, if, my lord, the order by which I was appointed as the Bengali Bengali translator, my lord, there was a clause that if I am removed from that post, I'll be given a grade 2 post. So my contention as of today before a lordship would be, my appointment, my lord, gradation in the gradation list, the appointment to the grade 2 post should be retrospectively shown so that I get the benefits of that particular period. I
When
have,
were you appointed? Which year?
my lord, the appointment is in
2010. But
3rd May 2010, page 25. Kindly comes to page 25. Just a minute.
sorry, sir.
Let me, sir.
1997, God division.
No, no.
No.
What division clerk 1997?
2000 promotion টা বলছি।
Promotion. Kindly comes to page 25. This is my order. This is the order passed by the learned district judge. May I place the order in its entirety, my lord?
No.
Page 26 onwards. In doing so, I have consulted with the gradation list of ministerial staff of the judgeship in respect of grade 1, 2, and 3. UDC, I find from the gradation list that the qualification of Sri Gautam Mondal is
So what is
M.Com.
the,
Yes.
now the post was filled on the basis of a recommendation
Yes.
without following due process.
My lord, I was eligible. I was eligible
No,
for
no,
the
you tell
post.
me whether rules permit such kind of
Promotion is
recommendation.
permissible. Kindly comes to the rules.
Promotion only on the basis of a recommendation.
Well, I was the only person who was there, eligible,
No.
But
according
there
to
must be
seniority.
certain criteria to be
And that
fulfilled.
criteria is page 24. That is the rules.
Yes, method of recruitment. And it says only the method of recruitment, it doesn't
Yes.
say the method of promotion.
Yes, recruitment means to the post.
Recruitment means
No,
promotion.
my lord, if it is from the selection from the feeder post, then it can be
Then
constituted as promotion.
everywhere it should be recruitment only, which will imply promotion. We need not go into the promotion
No,
rules
not
as
DPC.
such.
Not DPC, my lord. It can be, kindly sees the reasoning given by the at the time of my lord promotion.
Is
Kindly sees page 26 onwards, my lord.
yes, in consultation with the recruitment file, I find that the authority of such and such was requested District Employment Exchange Malda
Yes, was requested to recommend the names of candidates
was
for the post
requested
of
to
one
recommend
such and
the
such.
names of eligible
In reply,
candidates.
in such and such
Could
was
that have
concerned
been
only
done?
2 names as per
Can
such
the
and such.
district judge of a particular district seek recommendation from the District Employment Exchange?
My lord, contention is that, my lord, as that relevant point of time,
Then
it was selection.
why
Now, my lord, kindly comes to the next last page, my lord, which grants me, my lord, the benefit as of today that I am praying, my lord.
as such,
Last post of
what is
Bengali
it, sir?
translator.
There is a direction of Honorable Court that in order to make recruitment, wide publication is necessary to fill up of any post, but due to unavoidable circumstances, wide publication was not made as yet.
Yes.
As such, I do not like to waste any time for giving appointment to the post of Bengali translator in the
This was a
judgeship
temporary
of
arrangement. That is
Malda.
reasonings for
When
making the
there is a
temporary.
provision, why do you want to evade, sir?
No, I'm not.
When there
Being
is a
so, I
provision
have
and standing order of government for selection from amongst upper division assistants of this judgeship.
yes.
In doing so, I have consulted with the gradation list of such and such, such and such. I find from the gradation list that qualification of Sri Gautam Mondal is,
M.Com.
now he was working there.
Yes.
Both the above named employees are the UD assistants of this judgeship. The
Yes.
eligibility as a, both of them have obtained their respective government.
Now kindly comes next
Now,
paragraph.
the government recommended graduate with there are more in this alumni. So, sir, you have to place the rules, whether
Yes,
it was
rules is-
seniority come merit or merit come seniority, and
rules is
whether
page 24.
whether it was seniority come merit or
Amala,
merit
this
come
was a temporary
seniority.
arrangement. Kindly comes to rules, page 24. Bengali translation.
For the recruitment.
Yes. by selection from amongst upper division assistants or by direct recruitment through employment exchange.
So what is the process of selection? Just
Selection-
seniority?
Yes, selection,
So that's what I'm
selection.
asking you.
Malad, that
What
is
is the process of
eligibility.
selection?
Malad, my contention, malad, the query of the court is that as to whether this is merit cum seniority or seniority cum merit. In my humble submission, it would be seniority cum merit in view of the fact that the gradation list, while cancelling my appointment, it has been considered that I was junior, so therefore I could not have been given. So therefore, the criteria is seniority cum merit.
So
Seniority cum
it's
eligibility.
your inference, but
Well,
there must be a rule.
There is nothing to that effect, madam. May I just place the
No,
entire?
but there is a rule.
But now that is
No,
not on
but
record. No one has
that
got
is
it on
not on
record.
record, but then you find out.
Kindly
there must be a
kindly
rule.
comes to the last paragraph. This arrangement was made. Thereafter, in this connection, I would like to page 26. I am placing in this
But then
connection
see-
as a such and such. Accordingly, the candidature such and such will not be taken into account at present, but the candidature of the said post may be considered when its turn from such and such will arrive. Kindly comes to the operating part. Last, my lord, page 27. The reasons have been given. It is pertinent to say that the promotion of Sri Gautam Mundo is for the better judicial administration of Justice from Malda. The post of Bengali translator of this justice may fill up by any other eligible employees if occasion arises. Till then, Gautam Mondol, Sri Mondol will hold the post of Bengali translator. Sri Mondol may be withdrawn from the post of Bengali translator and may be transferred to any other grade 2 post in future for his substitute is selected. Subsequently, his substitute has been selected. My contention is that I should have been moved to any other grade 2 post. Subsequently, a recruitment process was initiated. My lord, kindly comes to the advertisement. Page 29 was the order by which this previous order was kept in abeyance. And kindly sees what were the considerations. Page 29. Representation has been made by the WBMOA. This is the matter employees organization, Civil Courts Unit Malda, and also aggrieved 11 employees who have been superseded, indicating some such and such irregularities in the office order. The aforesaid two orders being such and such are kept in abeyance. Gautam Mondol is now posted in the Court of Learned Civil Judge Junior Division, Second Court Malda. Let a copy of be given. Now at that relevant point of time, I had approached this honorable court. An advertisement was issued. Advertisement is P5. I have a typed copy of the advertisement, my lord, if your lordship is of the view that it cannot be read, my lord. Typed copy of the advertisement, kindly sees.
So this is a subsequent.
Subsequent.
A different district judge.
No, yes, different district judge, I think, yes. Different district judge, yes. The advertisement, my lord, kindly comes to the advertisement. It is 21st
So
January
against such
2011.
appointment, there was a representation.
Before
Okay.
this, my lord, I think the representation, may I just assist your lordship?
Yes, a
The
representation
representation
has been submitted
is
by such
in
and such.
2010. Advertisement
May
comes in
2010.
yes, advertisement in 2011. So because of representation, I am kept in abeyance.
P3.
Page?
Page 29, annexure P3.
Yes, 29.
A
I am at 20.
representation has been submitted by WBMOA,
Yes.
Civil Courts Unit Malda, and also aggrieved 11 employees
Yes.
who have been superseding,
Yes.
indicating some irregularities in office number such and such relating to Gautam Bishash and office order such and such relating to Sri Gautam Mondol.
Yes.
So which are these office orders? The one that you referred?
Well, the aforesaid two office orders being such and such.
One is
Yes.
122G.
This is 38th.
Yes,
This is my
122G.
promotion order.
And 115G.
Yes.
Yes.
122G is my promotion order.
Kept in abeyance until further orders.
122G that which I have placed just now.
And thereafter this
Advertisement was made. Now in this advertisement also, one post of Bengali translator was not advertised. That also
there was a provision. There was a provision.
I'm
Then
saying
exclusively on the basis of any recommendation, you could not have been appointed.
Subsequently, there is an advertisement.
Yes.
That is what that is the my lord, the contention. Now, my lord, I moved a writ petition. That is at page 41.
Now you come to page 44, P8.
Yes, this is the cancellation. In view of this is the impugn before your lordship.
Then there was a direction for preparation of gradation list.
Yes.
Is it done?
Yes, kindly, yes, it has been done. In view of the advertisement of the recruitment of such and such
See-
promotion, now kindly sees what is the reasoning. In spite of
removal of
lacking of
reasonable
eligibility
dates.
criteria. This is the reasoning.
In spite of lacking in eligibility criteria
Criteria of having honors in English or Bengali. That was not the eligibility criteria. Eligibility criteria was
were
MCOM.
kept in abeyance by such and such and
Yes.
required to be cancelled for removal of any anomaly in future.
Yes.
So
So the reasoning is the learned judge proceeded that I don't have the eligibility criteria, which is erroneous in view of the fact that, my lord, the eligibility criteria was graduate of any recognized university with honors, preferably in English, Bengali, or linguistics.
Hmm.
So now kindly sees eligibility criteria and thereafter kindly comes to the next page, page 45. This is the gradation list. Kindly sees my name appears at serial number 12.
hmm,
OBC MCOM. Now previously all from 1 to 11, these are the employees who must have given the representation. As of today, I don't know. They were not eligible. First one is HS, BA, HS, BCom, BA, BSc.
now did he sit for that examination?
Myself,
He-
my client.
Hmm?
No, I could not have because I am OBC. The post was for SC. One post reserved for SC.
So who is this Bapi?
Papi Sarkar is the person who has been who participated in the recruitment process and subsequently has been recruited. His order of appointment is at page 40.
So you are challenging his appointment?
Yes, yes. But my lord, after in 2011 onwards, he is working. My lord, my contention would be that subsequently I have been given appointment to a grade 2 post. Now, my lord, my prayer before a lordship would be, as of today, it will be very drastic to cancel everything, put everything, though in many matters this has been done in recent future, we have seen. But my lord, as of today, the balance would be, in my humble submission, that will be my prayer, that my promotion to the post of grade 2 may be fixed from the date when this particular order was kept in abeyance. So the order,
without being eligible.
well, that is the eligibility is pursuant to order of promotion, my lord. The ad hoc promotion which was given to me kindly comes on the last line of that particular order, 33/2010.
33, 2010.
10. That order that I am placing, page 28.
Which, what is the number?
Number is 122/G, which was
That
kept
has
in
been
abeyance.
cancelled.
That has been cancelled. That is the challenge before your lordship. I am challenging that, saying that this has been cancelled on a misconceived notion that I was not eligible and I was junior, or I was not eligible.
Okay.
While cancelling, the eligibility criteria has been erroneously construed to be only graduates in English and Bengali and linguistics, without taking into account that that was a preferential criteria. So therefore, that cancellation is erroneous. And my lord, in view of the fact that since that cancellation is erroneous, my lord, seniority in grade 2 post should be reckoned for that from that particular date. Subsequently, I have been given grade 2. In that case, I will be more senior and the consequential benefits will follow.
You want to be the Sharistar?
But I think I'm senior Sirsara as of today.
Today.
Yes.
When are you going to retire?
My lord, 29, I think. I have given, my lord, the gradation list in the affidavit in reply. Reply ta diyechi. This is the affidavit in reply, my lord.
Where's the copy?
Well, these are the replies, my lord. I have annexed the gradation list as of today.
Sorry, my lord, we have not received any copy of opposition of
Reply.
Whom are you representing?
Oh, or opposition আছে, or
Whom are you
opposition.
representing?
for the state.
Stated কি বলার আছে এখানে? এখানে কোথায় আমি কোথায় দেখাও তো।
High Court administration doesn't have any role in this.
We have also filed an opinion opposition in the matter, my lord. Probably that is on record. And the reply he is filing is in reply.
In what capacity was this page?
সরিয়ে যাবো কিন্তু ধাক্কা মেরে সরিয়ে দেবো মাই লর্ড আমাকে
What have you stated therein?
We have stated that he is claiming the benefit of this order, my lord, at page 28, that has been revoked by the subsequent order. Now, my lord, if he is claiming the grade 2 post from a retrospective date, my lord, he has accepted this order, my lord, which says that it may be withdrawn when a regular candidate is found. This order itself reserves the right to withdraw this facility granted to him. It was only a stopgap arrangement that he was provided with that particular post. Page 28, mother.
grade 1 senior sister
No, first of all, my lord, the when he was
আর এটা
promoted, number
এখানে
No, we will continue on the next state. Affidavit in reply filed by the learned advocate representing the petitioner to the affidavit in opposition filed on behalf of the respondent number 4,
For 4, my lord, I have just
4 and 5 separately be kept on record. 5 is the private respondent.
and on behalf of 4, my lord, it was filed earlier, my lord. I have not filed it today. Probably it's on record, my lord.
It's on record. And what about respondent number?
my respondent number 3, my lord,
You have filed the affidavit in opposition.
everything is there on record.
first time, my lord, hearing after we get the appointment.
And you?
No, my lord. I have not served any copy of the same, my lord, any opposition or something. No, my lord, I have not.
Have a
No,
copy of the petition with you?
my lord, just
You are appearing for the first time.
for the first time, my lord, for the state respondent.
The learned advocate representing the respondent number 1 being the district judge. 3. Then who is respondent number 1?
State, my lord.
State. Respondent number 1, the district judge Malda is to file the affidavit in opposition. The learned advocate representing the respondent state. Respondent number
1, my lord.
1.
State respondent.
You file the affidavit in opposition also. Is
My
to
lord, I
file
filed.
the affidavit in opposition on the next date of hearing. Now, what were you trying to file?
With your lordship, leave me, I am filed.
Affidavit in opposition filed by the learned advocate representing respondent number 5 be kept on record. So then you had received a copy of the affidavit in
Yes,
opposition.
yes, I have given the reply. I have filed the reply today.
তাহলে ওটা দেখি ওটা কবে অ্যাফার্ম করেছে? না না ওটা তো ফাইলিং ডেট।
Private respondent. Private is অনেক দিন না ওকেও দিচ্ছি
Respondent affirmed on 11th day of November 2011 be kept on record.
98305, 16 নম্বর বারে।
Hmm?
94.
I have been my lord promoted
No, that will look
to the
in-
post of grade 2 from
next
2013.
next date be fixed on 19th of September for no, তার আগে করি। 8th of September for filing affidavit in opposition by the learned advocates representing respondent number 1. Who is respondent number 2?
principal secretary.
Principal secretary. my lord.
1,
It covers
2, and
the state.
3.
my lord. My
State.
1, 2, and
1, 2,
1, 2, and 3.
3 my lord.
Next.
8th September.
8 September.
8th September. Biplab.
I am appearing on behalf of the petitioner.
Sorry, sir, can you use your mic?
My lord, the petitioner has
অফিস ওই মাইকটা কাজ করছে না, ওটা একটু
এবার অন হয়েছে না বন্ধ হলো?
in Regional Engineering College. He then, subsequently, it has become National Institute of Technology, Durgapur. My lord, the petitioner's father, while he was working as a group B staff in REC, Regional Engineering College, he has died. Subsequently, petitioner has given a job at the died in harness category. But at the time of job appointment, the petitioner Madhyamik appeared and having a national test certificate in mechanics. Subsequently, he passed Madhyamik in second division. But he joined in his service, my lord, in the March of 2000. My lord, subsequently, by an office order, your lordship kindly see the page annexure 3, P3, at page
P3.
Annexure P3 of my petition.
Which page?
My lord, page.
Yes, for 40.
40 page, sorry, I beg your pardon. My lord, office order. My lord, may I read the office order? On the consequence of retirement of staff members for attaining the age of superannuation, the normal working in some of the departments are being hampered badly. In order to overcome the situation on temporary measure, the following staff members are hereby transferred to the department noted against it. The petitioner's name is number 2, Sheikh Sahadut, office peon. Existing department computer center are department transferred to applied mechanics and drawing by an office order 13 November 2002. He was transferred to this department. And he was working as a skilled staff. All the works of a skilled staff he was performed. He performed. But he is a office peon. And since dead, my lord, he is working all the jobs of a skilled staff. My lord, another grievance is, he, at the time of appointment, all other candidates was given appointment according to their qualification. But the petitioner having a required qualification of skilled staff, he has not given the post of skilled staff. The post of skilled staff. My lord, he was working as a skilled staff, as a unofficial skilled staff. All works of the skilled staff he was performing.
From which date?
My lord, from
which date?
13 November 2002.
So you have come for regularization?
No, my lord. Yes, my lord. My prayer is, now the skilled staff, post of skilled staff has been abolished. In place of skilled staff, technical assistant has come.
So you want to be elevated to that?
My lord, I have a required qualification. I was performing, my service was utilized by the authority since 2002 till date. My lord, thereafter, my lord, I am coming on to that point. But thereafter, my lord, kindly come Annex P4. But the head of the department, Annex P4, page 42. Head of the department. Recommend the name of the.
It says, however, after the said sad expiry of late Sri M. Ghosh, the post of technical assistant grade 2 was abolished.
Abolished?
Then how can you?
Skill staff is abolished. Office
No,
peon
it
is abolished.
says the post of technical assistant grade 2 was abolished, and since then, Sri Kaur has been the only staff looking after the laboratory. If the duties and responsibilities of the laboratory till date have been nicely managed by Sri Kaur, the reason being by this time, firstly, Sri Kaur was promoted to the skilled staff cadre. And secondly, he also gathered enough experience through decades of his association with late Sri Ghosh. Therefore, after 13th October 2002, when on one hand we require an immediate replacement of Sri Kaur, side by side, if any laboratory attendant without any idea about the hydraulics laboratory is sent for filling up of the post of Mr. Kaur, the purpose of the laboratory will not be served satisfied. In this connection, I want to mention that Sri S.K. Shahadat, presently an office peon in computers section, is having ITI in mechanical trade, and he had also worked in our hydraulics laboratory for a few months under master role. If you kindly allow Sri S.K. Shahadat to join our department in post of Sri Kaur after his retirement, he would be able to manage the required job in the laboratory, and the laboratory can also function smoothly.
Recommended by the head of the department. Then. Thereafter, another malad for page 43.
Regular operation machine was performed after. So now he got the promotion on 6th of September 2004.
No. He has not given promotion. Malad recommended.
This is a recommendation. In this regard, if Mr. Shahadat is promoted to the cadre of skills and mechanic, whichever team feed, it will be proper justice to his skill and qualification.
HOD.
So it's head of the department.
Thereafter, my lord, the petitioner made an application under Section 6 of the Information Act 2005 to the information officer, and page 47 and 48. This was
Now, what was the fate of that representation, the recommendation?
nothing. No,
It was not
no
considered.
response. No considered. Thereafter, they have filed their opposition. In the said opposition,
There must be certain stipulated qualifications.
yes,
Sir, whether with due respect to the petitioner, having functioned as an office peon for a considerable period, to have been elevated as a skilled staff, or for that matter, a technical assistant in the laboratory, to supervise or to cater to the needs of the students as far as the hydraulics experiments, whatever, are concerned. Do you think it will be legal as well as conducive to contradict the prevalent rules?
but his service was utilized as a skilled staff. His service, not office peon. He was appointed as office peon, but his service was utilized.
What is the situation now?
Now, my lord, kindly, my
I
lord,
mean, why have you filed the writ petition?
my lord, I have filed my prayer. Your lordship, kindly come to my prayer portion, my lord.
Office peon can
Office
definitely
peon, I have a
can't
qualification.
only on the basis of your experience. Sir, can you claim that post
I have a
which requires, yes, madam,
My lord,
specific
kindly.
qualification,
My lord, we have
both
my lord,
academics as well as practical?
yes, my lord. And
Okay,
where
okay, I'll come to you.
My lord, your lordship, kindly come at page
What is your prayer, sir? Let
Prayer,
us-
my prayer is prayer to give promotion to the post of skilled staff, treating him as a technical staff according to his experience and technical qualification. Any department of the National Institute of Technology.
So only on the basis of your experience working as an office peon, you want to get yourself inducted as
Also, I have
a technical staff.
I also I have a TESOL certificate in mechanics, and I also
Okay.
passed Madhyamik
Can you show
examination.
any rules where you can be appointed as per your claim? That there had been a violation of such rules in your case exclusively.
But no, I have not annexed any rules.
You get hold of the rules, sir, titling you to such appointment as claimed by you. I mean, as claimed by the petitioner.
Well,
Heard the submission of learned advocates representing the petitioner as well as the
provide me the rules, my lord.
as they did not provide you with the I mean, they did not reply to your representation because they found you ineligible, and rightly so, sir.
They should reply my representation.
Next, you come prepared, madam.
I have, my lord. In fact, if my lord
Why didn't you reply to their representation?
My lord, I have annexed documents to my affidavit in opposition, which I would rely upon extensively. This matter has been heard on many occasions prior to my lord hearing it. There were certain.
So we will hear it finally.
My lord, I'm grateful. When would it please my lord to have it?
Heard the submission of the learned advocates representing the petitioner as well as the respondents at length. Next date be fixed on 9th of September for final hearing.
My lord, I'm grateful.
Next.
Mr. Pathak was appearing virtually, Your Lordship, for the petitioner.
Who is appearing virtually?
Well, I am appearing on behalf of the petitioner in this matter, my lord.
Yes.
My lord, your lordship, if you lordship kindly see your lordship's last order, my lord. Here, my lord, your lordship directed, my lord, the learned court below to my lord produce the case record. Here, my lord, I have prayed for my lord staying of the my lord disciplinary proceedings, my lord, in 2011, and the coordinated bench has already been passed, my lord, the order for staying the disciplinary proceedings during pendency of the my lord, criminal proceedings. And my lord, at this juncture, your lordship is directed my lord, trial court to produce the record to my lord know the status of the present position of the criminal case, my lord.
Yes. এটা কোনটা দিলে? What about the status of the criminal case?
Well, your lordship will find from the record, possibly the record has reached, my lord.
For a report, I am a de facto complainant there. I won't be able to know. I am just a witness there, my lord.
Okay. The report has been received. It seems. এটা রিপোর্ট আছে না কোনো? এখানে অন্য কোনো রিপোর্ট আছে কি? Hmm. রিপোর্টটা কোথায়? রিপোর্ট সাবমিটেড বাই ডিস্ট্রিক্ট জাজ বাঁকুড়া। ডিস্ট্রিক্ট জাজ বাঁকুড়া কোনো রিপোর্ট পাঠিয়েছিল দেখি।
বলো বলো ফাইনাল হিয়ারিং to the state
Yes.
regarding কোন application saying nothing
It is in the process of recording evidence. Last evidence of PW5 was recorded on 4th of July 2024. Thereafter, the next date had been fixed on 2nd of April 2025 for further evidence. It has
that
not.
the case is pending. Now the question remains before your lordship, in a pending criminal case, can I proceed with the inquiry, domestic inquiry or no? Lordship, now it is
that has been stated way back in 2011. They have not filed any appeal, not they have filed any application
But
for
the
vacating.
wheat has come in a final hearing, lordship. So
Yes.
lordship,
So here out the mail application. I don't mind, my lord.
When was it stayed? Show me that order.
In 2011, my lord.
But lordship, I am giving you.
My lord Justice Arijit Banerjee, my lord.
Your lordship kindly takes up
2011.
Yes, my lord.
কপি কে অর্ডার নেই এখানে, অর্ডারের কপি গুলো কোথায়? এটা তো নেই তো।
No, sorry, my lord. 2014. Sorry, my lord. I may be excused, my lord. 2014, my lord.
2014.
14, my lord. At the very first day, my lord, it was stayed, my lord. And subsequently, it was extended, my lord, till my lord disposal of the writ application.
You have a copy of that order? 2014 order? Do you have a copy?
Yes, ma'am.
But my question will be in 2022, it was dismissed.
Which was dismissed?
This writ application. If your lordship kindly takes up order dated 12th July.
It was dismissed, then restored with again, my lord, with interim order. My lord,
Then what happened? You proceeded with the disciplinary.
My lord, it was dismissed for default. My lord,
So
thereafter
that
it was my lord,
that is-
restoration
That
filed
is
and
with regard to your writ petition.
yes,
So your petition was dismissed for default. Thereafter, you restored it.
Restored
yes.
with the interim order.
Restored it when?
Restored with interim order, my lord.
Restored with
When?
2015 thereafter.
2015. So the proceedings should have been stayed then.
Yes.
If your lordship kindly takes
Since it got dismissed for
in
default.
22. 22.
Then it was restored.
That much I can understand. It was dismissed in the year 2015. Yes or no?
No.
No, my 22, my lord.
22.
Yes.
And then it was restored. Restoration application was filed in time. It was restored with interim order.
With interim order
Yes.
when?
That order we need to
In
see.
my lord, passed by my lord Justice, my lord
Sir,
Rajabasu
when
Chaudhary.
was it restored?
In 2022 itself, my lord.
So what did they do in the intervening
No, they
period?
are not
have
proceedings. My lord, they are not proceedings. They are not proceedings.
They have not proceeded.
No, they have not proceeded, and the matter was as it is, my lord. Still,
So
my lord.
you want this writ petition to be stayed till the disposal of the criminal proceedings?
Yes, that was the interim order, my lord.
Where is it?
That was the interim order.
Lordship kindly come to order dated
এই অর্ডারটা রেকর্ডে নেই কেন? এই
order
অর্ডার
sheet
কপিটা
That was the interim order, and that was, my lord, subsequently it was, my lord, extended, my lord. And basically, my prayer is also, my lord, for staying the, my lord, disciplinary proceedings till the disposal of the criminal proceedings, my lord.
Lordship kindly look into this.
Now the interim order past hearing will continue for a
Justice Arijit
period of
Banerjee.
8 weeks.
Yes.
from date
Yes.
or until further orders, whichever is earlier. So where is
My
it
lord.
that it will be stayed till the
No,
determination of
thereafter, my lord,
criminal
it was
proceedings?
extended, my lord. Kindly see, my lord, subsequent
That is a
orders, my lord.
Now,
issue altogether.
now, Lordship, kindly see the order dated 9/9/2024.
My lord, unnecessary, my learned friend is, my lord, taking the advantage. See, I am appearing, my lord, in virtual mode. Knowing fully
Who
well,
has
my learned
prevented
friend.
you from coming to court?
But today, my lord,
It's
I
your
have, my lord, some
prerogative
difficulty.
to appear online.
No, I have some, my lord, I have some difficulty. Every day, my
Then
lord, I
why are
appear.
you making such statements?
No, my learned friend knowing fully well, my lord, that it was extended till further order, my lord, until
Sir,
further order.
extension from time to time doesn't imply that it had been already extended till the period the criminal proceedings gets conclusively determined.
No.
Then
It was extended, my lord, until further order. It was extended until further order. That's why, my lord, kindly allow, my lord.
what
my
is
lord,
the
fixed.
date? 19th of April 2024.
19th of April or 9th of April 2020.
This is that restoration application. Allowed with petition restoration along with all the interim order as well as subsistent on the date of dismissal. So this was on 19th of April 2024. And then the determination got changed.
Yes, my lord.
Yes.
And thereafter, matter was heard, my lord, before your lordship, and your lordship directed the trial court to produce the record.
Now then you on the next occasion appear before the court.
Yes, my lord.
You appear
But
before the court?
yes, my lord. Last day I also appeared. They have not appeared, my lord. Kindly, my lord, see your lordship's last order, my lord. Last day I physically appeared. Today, my lord, I have some difficulty.
Both of you want to play hide and seek and get the matter delayed. What can be done?
No, my lord. I kindly fix one day, my lord. I will come, my lord.
Lordship, this month 22nd and 28th, except this two.
The learned advocate representing the petitioner appeared online with his junior advocates being present before the court. The learned advocate representing the respondent, Eastern Coalfields Limited, is also present. Next date be fixed on 28th of August.
Except 28th and 22nd. These 2 dates I have a personal difficulty.
29th of August. And you have a junior?
My chamber juniors cannot appear in this matter.
No.
Advocate on record can appear.
Madam, you too don't appear.
That because of her health problem.
Fair enough. But then you take the responsibility. If he doesn't appear, then you go and fetch him from anywhere you want to. Okay.
Well,
next.
I'm deep.
Get full divorce.
Yes, I am appearing for the respondent. Pleadings are completed and
I am appearing on behalf of the PS in this
notes
matter.
also filed.
Lord, on the last occasion, Lord, when the matter appeared on 23rd of July, Lord, on my Lord's pleasure was to adjourn the matter because I intended to file some two more judgments. I have served the copy of the judgments upon my learned friend. Lord, I'm handing up the copies, photocopies of the judgments, Lord, for Lordship's brief. Come to this section. Come to this section. All affidavits are complete. Written note of arguments have been exchanged, Lord. And the
You wanted to place these two judgments.
for that. Deleted copy.
So I'll fix a date if you want to submit anything further, you can do, and otherwise we'll finish it off. Ashwin.
I have always bowed down to your lordship's
The learned advocate representing the petitioner has placed certain decisions in support of the claim of the petitioner. Let the same be kept on record. Next date be fixed on 2nd of September for final hearing.
May I add one thing, subject to lordship's pleasure and subject to convenience of my learned friend also. Lord, having gone through the entire
2nd of September, sir.
2nd of September, that is, Lord, one thing I want to add, Lord. Subject to your lordship's approval and the convenience of my learned friend. Having gone through the petition very thoroughly, I have found that a copy of the suspension order has not been given. I'm just praying, or Lord, I'm making my humble submission before your lordship and a request to my learned friend to serve me a copy of the suspension order.
My lord, on the last occasion, your lordship already hold. My lord, 11 call notice has been, my lord, served upon him. He did not choose to, my lord, attend the inquiry proceedings. Thereafter,
Place the case records then.
yes,
on the
I will.
next
I will
record.
come
The
with the
learned
case
advocate
record. Yes.
representing the respondent. What is it? BSF or CISF?
CISF. CISF.
Is to place the case records pertaining to the disciplinary proceedings instituted against the petitioner on the next date of hearing. Next.
As the judge says, the 2nd September is cut. I say, forget of that. Think of the
Sir, please let, we are running
Yeah,
1 hour late. Next. 26.
My lord, in this case, yesterday, my lord, they instructed me not to proceed with the matter. But
so, sir, what about the written instruction?
My lord, they do not want to proceed with the matter.
Yes, sir.
So I
They
have
must
to collect the, my lord, the letter
Acha.
from them.
The learned
So lordship
advocate,
kindly adjourn
the
the matter.
learned advocate represented the petitioner submitted that the petitioners declined to proceed with the hearing of the instant writ petition. The learned advocate representing the petitioner therefore seeks a week's time.
My lord, 2 weeks time, 2 weeks time.
A fortnight's time to place the written instruction before this court to that effect. The learned advocate representing the Respondent Union of India and others is present. Next date be fixed on 19th of August for filing the written instruction as aforesaid. Next.
Your Lordship, I'm on behalf of the respondent. Your Lordship, our counsel, Mr. Sushanto Pal, he's appearing into some other court. So, Your Lordship, as per your directions, we are supposed to submit the written notes of argument. So, kindly accept it.
None appeared to represent the petitioner. The written notes filed.
So, item numbers 33 and 34, Your Lordship.
Learned advocate representing the petitioner as well as the respondents are present. The written notes of argument submitted by the learned advocate representing respondent number 1 be kept on record. দুটোতেই একই order হবে.
Lordship, I'm filing the written notes of argument in the second matter, Shantanu Banerjee, item number 34, Your Lordship.
What about the earlier one?
That has already been filed, Your
Okay, the
Lordship.
written notes of argument filed by the learned advocate representing the petitioner in which item?
Item numbers 33 and 34, Your Lordship.
You are filing written
Item number
notes in
34.
WPA 21649?
Lordship.
Right তো?
Lordship.
WPA 21649 এটা একসাথে হবে না, এটা আলাদা আলাদা আছে। হ্যাঁ হ্যাঁ be kept on record. Next date be fixed on 9th of September for final hearing.
Lordship.
Next. ওই দুটোই একই হবে বোধহয়। হ্যাঁ next.
For the petitioner, my lord. I'm led by Mr. Anindo Haldar, my lord. He's coming. On the way, my lord.
Yes.
But on the last occasion, they submitted certain documents because a person has been.
They had filed, they had placed the original case records uh, pertaining to that GSFC trial.
May I get a copy of that because they are disputing that we were not crossing the border, Milord. As they near the border, Milord, the firing took place, and Milord, the husband of the petitioner died. Milord, we are paying for compensation. They are saying that we tried to cross the border, Milord. No case has been registered, Milord, nothing. Milord, Milord, our contention is that, Milord,
You obtain a no, this is a GSFC trial. You can inspect the records.
Milord, they have never given any inspection, Milord.
You can inspect the record from the court itself, right?
Kindly grant me that leave.
You know, Partha Ghosh. The learned advocate representing the petitioner seeks permission of this court to inspect the original case record pertaining to GSFC trial held against the petitioner as filed by the learned advocate representing the respondents, which had been kept under proper custody of the court clerk. Full stop. The learned advocate representing the petitioner can inspect the case records as aforesaid in the presence of the learned advocate representing the respondents as well as the court clerk during after the court hours on August 14th. In the meantime, you can serve them a notice to that effect to be served upon the learned advocate representing the respondents and file an affidavit of service to that effect, because today none of them appeared. None appeared to represent the respondents.
14th August after the quota.
After the quotas.
Great.
Next.
36, I appear for the petitions.
I appear for the Kolkata protest. Pursuant to Lordship direction, we have prepared one chart. So for the promotion and examination.
Have you given him a copy?
Yes, we have copy there. ঠিক তাহলে একটা নাও আমার বললো কপি দিয়েছি
না না আমাদের দেন
ঠিক করে কপিটা আগে দিয়ে কালকে আমাকে একটু জিজ্ঞেস করবে যে সার্ভিস করতে
I think this will suffice.
May I go through and come back, Malad?
Okay, but sir, you have to file this in a form of an affidavit.
In form of an affidavit.
The learned advocate representing the respondent in compliance with the order dated 14/5/2025 has placed a chart before this court, which is required to be filed in the form of an affidavit. Eta diye din Firot. The learned advocate representing the respondent, Kolkata Pro Trust, is to file the information stated in the chart placed before the court today in the form of an affidavit, serving a copy of the same upon the learned advocate representing the petitioners in advance.
Should I keep this or return this?
That is your mutual understanding. Next date be fixed on 3rd of September. Next.
Good.
Next.
We are applying for the respondents. The affidavit complete. No, no. Form হয়েছে কি আমরা ফার্স্ট টাইম অ্যাপিয়ার করছি
So
Well,
nobody
we are,
appeared, sir.
yeah.
Yesterday
we are
also no one. No
I
one
don't know,
came.
my lord. We are appearing for the first time, my lord.
First time.
Yes, my lord. The pleadings, my lord, affidavit in opposition copy we have, my lord, but we do not have any copy of
Did you
reply.
file affidavit and reply?
If it's not right now with me, my lord, kindly give.
Are you the advocate on record?
No, my lord, I'm not the advocate on record.
Then?
I'm the junior to advocate on record, my lord. Mr. Devashish Mukhopadhyay is advocate on record. But it's not here in the court right now.
Reply.
Let the matter be the learned advocate representing the respondent, Union of India is present. You have appeared for the first time, sir,
Yes.
today.
Yes.
Let the matter be fixed under the heading to be mentioned tomorrow. Sir, to be mentioned tomorrow, ask your senior to be present tomorrow. Next.
Reply 42 minutes I am for the petitioner. Then the petitioner for the CSC led by Mr. Singh.
But I pay for the state respondent.
On the last occasion, your lordship was pleased to make DIG CID party, and I have start copy upon them.
So the amendment has been carried out?
Your lordship directed the department to cause amendment.
Yes, they have done it. You have received the copy of the
Lord, I have received. Petition I have received.
based upon your observation, they have taken the steps.
Lord, initially I find Millard by a memo, Millard, he was found unsuitable. Because Millard, the place of education from where Millard he have gathered his qualification, that was closed during the time as alleged to have been taken the qualification. Initially that was done. Millard, subsequent to that, Millard, will allow me to come back to your lordship.
That is a mistake. Their mistake will I suffered. 2003 Millard appointed.
No, my lord will kindly look into this memo.
Do you want to file an opposition or you want to file?
Millard, I must not oppose, Millard. May allow me to file a report.
The learned advocate representing the respondent number 4.
I did respondent.
Seeks time to file a report in the form of an affidavit
Kindly give me some
regard to
time.
the contentions of the petitioner in the recent writ petition, and the same is allowed. So he is partly the state, partly the DIG.
Yes. Part of the state and part of
So he will take 2 or 3 times.
Yes.
As your lordship please.
So I will not give you that liberty.
Any more time.
So it should be shorter date.
Yes. As your lordship please.
So that I can fix it up for
As your lordship.
date as
my lord please.
possible, because in any case, invariably on the next date, you will come and seek for time.
I do not prefer time every time, Millard.
The one who is standing besides you,
I do not, Millard.
he comes and gives.
I
proxy
always,
for
Millard, try
others.
to, Millard. I know that this court is very strict.
File the report, my
Next date be fixed on 25th of August for filing the report in the form of an affidavit. Next.
I just opened the case yesterday. Where I was taking your lordship to the writ petition. The writ petitioners number, there are 3 writ petitioners. Initially there were 2. Subsequently, kindly with lordship, another person has joined.
So you had referred to annexure P1, Deputy Public Relations Manager.
I'm thankful.
Now, the total number of posts were 6. Thereafter, you had also indicated about the
qualifications. For recruitment at E3 level, skipping 1 and 2, one had to have minimum 4 years of post-qualification experience in some reputed organization of the similar line. It is not a one-time appointment, it is a regular system like that. What happened? 2010 they joined. In 2012, Coal India decided to introduce some structural change in the recruitment system. What happened, Lordship? Kindly come to Anakshar Bolo. Will be Anakshar. Kindly come to P4. P4 below. Annexure P4. Page 40.
Yes.
Subject is recruitment of management trainees of all disciplines through open advertisement and through campus will be in E2 grade in first year and subsequently placed in E3 grade after successful completion of 1 year training. The change was, it happened to be recruitment from outside, fresh graduates, fresh postgraduates, or from campus recruitment used to be in grade E1. After completion of 1 year, successful closing of the probation period, he will be regularized in E2. That was the system, existing system. Now, what was the change introduced? Para 1. Recruitment of management training of all disciplines, either through open advertisement or through campus, will be in E2 grade in the first year. There is a jump of 1 rank. And they will be placed in E3 grade after successful completion of 1 year training.
Yes.
Lordship has appreciated the change. Instead of E1, it will be E2 and confirmation will be in E3. On that point, we have no grievance. We understand employer has the liberty to do it. Next, management trainees who are at here the soup inches. Management trainees who are at present in E1 grade or those management trainees who have been appointed on or after 1/1/2007 would be deemed to have been appointed in E2 grade. And after successful completion of the requisite training, they would be deemed to have been placed in E3 grade and their pay will be appropriately fixed. All those management trainees who have been placed in E2 grade on successful completion of training between 1/1/2007 to 31/12/2010 will be placed in E3 grade from the date they were placed in E2 grade and appropriate pay fixation. They introduced a legal fiction. People who are inducted as management trainees, much below us in E1 grade, were lock, stock and barrel, given a deemed promotion or upgradation to E2 and confirmation to E3. What happened, my lord? Can you visualize the picture? Management trainees were fresh from college without any working experience beforehand, recruited after us in E1 grade, whereas we were recruited in E3, were given a big
Was there any difference in qualification?
Yes. Here, a post-qualification experience is a material thing. Management trainees of all disciplines are minimum graduates, be it engineering graduate, be it law graduate, be it a degree in HRD, whatever.
You mean to say that they had been given
a benefit,
arbitrary advantage?
No, they were given all right, but the retrospective effect. Existing people who are recruited after us, they were given this jump. Hey, if the policy had been prospective, henceforth we couldn't say anything. We would have nothing to argue. But once you give it, with retrospective,
you mean to say that they had been given the opportunity to supersede you?
To supersede me. exactly not supersession because they are not my discipline. There are other disciplines, all disciplines across the board. It was a structural change that was introduced. There is.
So don't you think it's the discretion and the prerogative of the
Lordship,
administrative body?
I respectfully bow down to your Lordship observation, but when it comes to retrospective effect, it is not. My submission is, had it been prospective, I would have no grievance. The people henceforth would be recruited in this manner, I have nothing to say. But who are recruited 2 ranks below me in whatever discipline, below the coal executives, they live in colonies.
Now, do they follow any kind of rules for such recruitment?
No, it was a companies took a resolution and implemented this. This became the rule henceforth. That becomes the rule. There is a compendium that is called Common Coal Cadre. That is a compendium of all the rules of Coal India executives recruitment to retirement. With this, it will be an amendment to the rule, to the coal cadre. So this becomes the rule. And this retrospective part is, of course, a one-time thing. Thereafter, it will be a continuous process for future. So this one-time thing changed our status vis-a-vis all the disciplines and recruits after us. This should have struck the conscience of the management. And practically, kindly visualize this. We are only 3 people. We call it, if I may excuse the expression, Gaurave Bahubachan. We call it a discipline, but we are only 3 people who were recruited in 2010 in E3 in the Public Relations Department. And this is across the board, all disciplines. So we were found to be pariahs. We were separated for no reason. This was appreciated by the management. Not that they didn't understand this. There comes the corroborative picture of what I am saying.
Yes.
The medicine discipline, medical disciplines, similarly, like us, they are also recruited with post-qualification experience and postgraduate degree. Medical is a quite big discipline. There are hundreds of doctors in Coal India, throughout India. That is a very big discipline. Because of their size, because of their volume, they caught the attention of the management. In their case, what was done? Kindly see. Kindly see annexure page P5, page 41.
Yes.
The recruitment of medical officers as senior medical officer and specialist in E3 grade and senior specialist in E4 grade respectively. The Board of Directors of CIL in their 277th meeting held on 30th January 12 has approved the following. Recruitment of medical officers who are MBBS, BDS stands for Bachelor of Dental Surgery, and who possess specialist qualification with less than 3 years experience as senior medical officer will be in E3 grade. Recruitment of persons having postgraduate qualification, specialization with 3 years experience will be in E4 grade. The material parties kindly come to point III. Medical officers and specialists who were appointed on or after 1/1/2007 in E2 and E3 shall be deemed to have been notionally appointed in the E3 and E4 grade, respectively, and their pay will be fixed appropriately. The same tragedy, the same adverse consequence was suffered by the doctors like us. They provided the remedy. They were lock, stock, and barrel, given the same benefit. Existing people. We were deprived.
3 of you.
3 of you. Only 3. Coal India, like a mighty big organization, it will make hardly any difference.
But sir, they had been senior medical officers and specialists.
Yes.
And you had been the management trainees.
No, Lord. I couldn't explain. We were recruited from outside, not as management training. as a regular
But the
officer in
per-
E3 grade.
But the page number 40 that you
No,
referred,
that
it
is-
says subject matter recruitment of management trainees.
Lordship, it is happened. It has happened. These are for management trainees. That is the basic recruitment stage. Entry level post E1. It is for all the disciplines. Minus sans the public relation. Because what is the logic? Public relationship managers do not grow in the company. They cannot be given on-job training as such. It is a mining company, out and out a mining company, a company of engineers. Engineers or HRD or finance, they would be getting on-job training. So they are recruited as management trainees. Whereas we, of specialists with a specialist domain of knowledge, a public relation, that doesn't happen in Coal India or in a company like this. It happens as a journalist. It happens as an advertisement person. It happens as a public relation officer in some other company. So they recruit public relation officers in E3 grade. In E3 grade. They don't get in-house.
You mean to say that prior to your induction in the E3 grade, you had served elsewhere?
Elsewhere.
With your adequate knowledge and experience.
With 4 years post-qualification experience. Out of the college, we worked for 4 years under some organization, and the criteria is given. I will go back to that advertisement once again.
So, were you directly appointed in E3?
E3.
Directly?
Directly. Therefore, I will go back to the advertisement once again. P1, no? Where is P1? Page 29. Lordship, kindly.
Yes, E4, E3.
Bottom of the page.
And what was the qualification?
Qualification. The last bold entry. Qualification.
Experience 4 to 7 years.
Or PG diploma 2 years. Graduate degree in public relations, mass communication, journalism.
And what is the qualification required for management trainees? Otherwise, where is it written?
Graduate of any discipline.
Where is it written, sir?
I have to show I can show the coal card. I'll come to that.
So these were the people.
For the present purpose, your lordship may take the word. The graduate is the qualification. That recruited from campus or from open management. Any fresh graduate of mining, of chartered accountant, anybody can apply.
In opposition, with regard to public relation, the minimum qualification which is required, we have indicated in our opposition at page 17 regarding management training. But it will be postgraduate degree or postgraduate.
But then can that be different from the one that appears in 29?
Yes, yes.
Then you are publishing an advertisement with a different.
What at that relevant point of time when the petitioner was appointed, there was public relation was not a discipline. It became a discipline in the year 2016, which we have annexed in our opposition.
So, sir, you are not governed by this P1.
At that relevant,
yes,
advertisement. It is an advertisement.
But he says something else.
I will explain what he says. I will place his affidavit in opposition as well as my petition. I am not hiding anything. I can't play hide and seek with the court. I will place everything below. Kindly come to the last entry, qualification. What qualification we had to have?
No, sir, you were on page 40.
Oh,
now that.
No, I'm gone back to the advertisement. Page 29.
So this I have seen. 29 and 30 I have seen.
Achha.
Qualification 4 to 7 years of experience that I have seen.
Yes, yes. That is material. In case of management trainees, no experience is required. I don't say they are less qualified. They are fresh from college or university. Whereas we had to have post-qualification experience. Therefore, we had the advantage of getting recruited in E3 directly.
So now you seek parity with the ones in the medical department.
The core of my prayer is, I seek a remedy the doctors were given. With the existing people.
That's exactly what I said, sir.
Yes. Correct, Your Lordship. My gut feeling is Coal India, because it is very small people, only 3 people.
They have neglected you.
They say
or ignored you or missed you.
They missed me, simply. After filing the case, they have taken a bellicose attitude and started fighting it. Simply miss. Nothing else.
You find out any scope for rectification of your mistake?
No, ma'am. There is no scope.
So then they are not accepting their mistake, sir.
There is no mistake at all.
Then Your Lordship,
That's what I'm saying.
there was a mistake. Then Your Lordship will hold there is a mistake. Let me place the petition.
Sir, today again it's 1:40.
Continue tomorrow, my lord.
Tomorrow, Mr.
For
Vasu
editing,
has come.
A short date. That's why I'm only praying.
Well, let it be continued. If my diary of my lord permits.
No, today it would have been done, but some.
My lord has fixed matter at 2 p.m. also today.
No, because we lost on considerable time due to.
Yes.
For the submission of learned advocate representing the petitioner as well as the respondents. Next date be fixed on. 26th of August. 26th of August.
26th.
এটা কত নম্বর ছিল?
কোনো এরিয়ার গল্প নেই, ন্যাচারালি ফিক্স হয়।
Rest of the matters are.
খালি শেষ হয়ে গেল? না, হয়ে গেছে, ঠিক আছে। আমি একটু দেখবো, হ্যাঁ? না, এটা তুই আমার ওইটা দেখ। হ্যাঁ। এটা
পরে হবে আজকে না কন্টিনিউ হবে
ঠিক আছে বড়টার তো চ্যাসেন গেছি পাঠাটা দাও
নিউজটা নিয়েছিলাম
সিরিয়ালি নেবে দাদা সিরিয়ালি নেবে বলে দিন না অ্যাসাইনমেন্ট ম্যাটার বলছি 2 PM এ লেখা আছে না ফর অর্ডার অ্যাসাইন ম্যাটার সেগুলো আগে নেবে কি তার মানে সিরিয়ালি নেবে তাই তো সিরিয়ালি নেবে মানে এসে দেখতে হবে
কিরম আছে এদিকে ঠেল না
কি গো অ্যাডমিশন হয়েছে না আসছে ভেজ আচ্ছা তরকারি
আনতে গেছে এখনো জানি না খাবার খাবার খাওয়া যাবে
আজকে বাঙালি খাবার
ভালো ভালো
এই আজকে দূরে বসেছে আজকে আবার দূরে বসেছে
ওয়েট করো ভালো ভালো জিনিস আসবে
আর ওকে আর সবাই মিলে ভাগ করে খাবো আমি আনতে গিয়েছি
হ্যাঁ 10-12 बुढ़ी अरे दादा 10 जलेबी बोल दिए अरे 2 दिन से क्या तबीयत ठीक नहीं था क्या না জিলিপি ওদের বানানো থাকে
এই মুড়ি বলছি আরেক জায়গায় নিবি মুড়ি কোন জায়গায় নিবি ঠিক আছে আর ছোলা বাদাম যেরকম নিচ্ছিস নিবি আর ওই জিলিপি নিয়ে না কটা খাতে
10
আরে 10টা জিলিপি নিয়ে নিস 10টা জিলিপি নিয়ে নিস
একটু হাওয়া আর একটু বাতাস দেবে
এটা তোকে আমি ফোন পে করে হ্যাঁ আরে বাবা ফোন পেতে দিয়ে দিচ্ছি তোকে ওরা ফোন পে নেয় না
সবাই জেনে গেল
কত হচ্ছে দেখ
সবাই জেনে গেল খাবার
हाँ
सीट लिया
तो
हम निकल इधर आ जाओ
हाँ तू इधर आ जा तू इधर आ जा उधर
खाना खोलने के बाद वो
আবার
তোমার ফোনে
একটা অ্যাডভোকেট আর একটা how to give just one
दो दिन देखा था परसों तो हम आए कल हम नहीं आए कल मामला मामला देखते একজন মামলা করছে আমি ফোন করে মোবাইল হতে না
मेरे पास नहीं
এই ওকে ফোন পে করতে হবে দাও না আরে মোবাইলটা দে এই সাবির এই সাবির এই
भाई
साबिर
अपना मांग रहा मोबाइल भी नहीं दे रहा है
अरे उसको फोन पे करना पड़ेगा उसके पास कैश उतना नहीं
अगर दुकान में फोन पे लेता है बोल के लगता नहीं है
अच्छा फोन पे
चाचा पूरा कैश वाला है चाचा उसे फोन पे नहीं है यार ये लोग पहले ही समझ गया है कि मोदी बाद में टैक्स बैठाएगा वो नहीं
अरे मोबाइल तो दे ना मोबाइल तो दे लिया এই সাবির মোবাইল দাও না ওকে ফোন পে করতে হবে ঠিক আছে ক্যাশ নেই আমার আরে আমার ক্লাসে থেকে তো ক্যাশ আমাদের জন্য আসছে স্যার অবভিয়াসলি দাও তোমরা তো ছেঁচা তো থাকবেই
फोटो में तो आलू पोस्त खाচ্ছে पावानी थैंक यू আমি বলেছি চাউমিন আর দই বড়া এই মালাগারটা কিরম আছে গো? কিরম আছে? দিয়েছে ছিল তো
আগে ছিল
কোথায় কোথায় নিয়ে গেছিল? এখান থেকে ভালো করে তো পিজি অন্য কোনো জায়গা স্কুলটা এরকম করে
না না
কি নাম জানো?
আরে এখানকারই প্রোডাক্ট
হ্যাঁ 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 হ্যাঁ
আমি যাচ্ছি আর তুমি এসে সামনে কাবলিওয়ালার মধ্যে দাঁড়িয়ে আমি আর অন্য কাউকে আমি আর
নিচে দেখো তো শোনা আছে
এভরিডে কাল থেকে আরম্ভ করে
থাকলে চারটে নিয়ে আসো
আমার ডিউটি तो 30% तो दान खाता में चला गया 30% तो दान खाता में चला गया तो बावजूद गवर्नमेंट 40% है अब আমাদের চান্সটা মধ্যে কিনতে যাচ্ছে চাউমিন পেট চানা
এগুলো
আমারও আছে নিয়ে আসবে না না
বলে হ্যালো এটা দিয়েছো একটু কিছু কমাও বাড়লে তো মুশকিল আবার কি বাড়াবে মুশকিল হচ্ছে আবার কত টাকা বাড়াবে যেটা বাড়বে বলছো 11,000 টাকা করতে পার 11,000 টাকা টোটাল হয়ে তবে সেটা বলছো
হ্যাঁ হ্যাঁ দুদিন বলো
ভাই তোমার কাজ আমি যদি এত কাজ জানতাম তাহলে আমি কাজ করে নিতাম না আমি কি এত কাজ জানবো তোমার কাজ তুমি খালি আমাকে বলো কত রেটে তোমার নামটা তো আমি বলবো হ্যাঁ আপনার টাকা দিলে ফিরিয়ে যাবে দাদা
ভিডিওটা দেখেছো হ্যাঁ রিয়েলি থিং Giving a second.
অথচ রুগীটা যেতে যাচ্ছিল রুগীটার ওপর থেকে
ফোর্স এত ছিল যে আর ঘোড়ে নি সোজা হয়ে গেছে যা পড়েছিল সব ক্লিন
কবে থেকে চালু করতে পারবে বলো আমি তাহলে
ওকে
ক টাকা অ্যাডভান্স তোমাকে দিতে হবে
পেয়েছিস তাড়াতাড়ি আয়
আমি আমাকে একটু সপ্তাহখানিক আগে জানিও কেন আমাকে তো ওকে করতে হবে ওখানে জায়গায় থাকতে
না দাদা থ্যাংক ইউ খাবারে আমার কোনো রাগ নেই এই সবকিছু মারামারি তো এই অন্যর জন্য সবকিছু মারামারি তো এই অন্যর জন্য কেন আমি আর 4টে মুসলমান হবে কেন সেখানে তো অশিক্ষিতটা আমাদের বেশি বেড়ে গেছে ইস্ট কলকাতা ডিভিশন তো তোমার আর এখানে
निकाल लिया अपना
क्या का नहीं हम निकाल लिया
তোমাকে ঠোঙা দিয়েছি 60 মানে 75 দুজন আপ তোমার সাথে আছে
এটা না
ফ্রুট খাওয়ার আগে খাবে प्रॉफिट डाउन तो भाई
সিঙ্গাটা ভীষণ ভালো কে বলে আমাদের ঠিক আছে
সপ্তাহ যে কোনো দিন থেকে শুরু করো
দাদা
সপ্তাহে আমাকে ডেট বলো কোন ডেট থেকে করবে আমি
इधर देखे
কাজে বেরোবে না বেরোবে বাড়ি ঘর তো আমাদের তার থেকে বলে দিই আসছি দাও ঠিক আছে
ওখানে দিন জিডিপি দে এই তো এখান থেকে এখানে রিপিট
Thank you. Okay. Sugar. ভুল করে ভালো করবে ঠিক পয়েন্ট খালি পরীক্ষা হয়ে যাবে और आएगा नहीं इधर लेगा तो बाकी अच्छा अभी नहीं आएगा আমার তো আত্মা দেখো দিকে সাপ্লাই করে মাটি में हुआ थैंक्स थैंक यू रवि সিঙ্গাড়া আনন্দ লাগে বুধবার শুধু খেতে আসি না খাওয়াতে বলি না আগে না এরা সব
जलेबी चाचा का नहीं है तो जलेबी चाचा का
চাচা ভাই তো আপনি যাচ্ছে তাই তো এটাই
এটা কিন্তু বললো না কেমন তেরা জায়গা ছিল এক জায়গায় মোটা এক জায়গায় সরু কেমন একটা আমি যেটা পেয়েছি জানি না সবাই একই পেয়েছে
সে কি রবিদা পানি কেন
দেখি সরুটা এক জায়গায় মোটা
গোলাস করেছে চুট অনুজ বিশ্বাসই করছে না ওদের হতেই পারে না
আচ্ছা দেখি আমার জলপিটা কি রকম আছে
আমার একদম গোল আছে
এই যে মধ্যখানে এই যে দেখ মধ্যখানে টিউমার
জিলিপি না একটা পকোড়া
এটা টিউমার
এটা জিলিপি না একটা পকোড়া
জিলাপিতে টিউমার থেকে জানতাম
বাঙালি মুড়ি হবে বিদেশি হোক খাবার এই তো সুযোগ
हाँ एक जलेबी रखा है अगर नहीं जान कोई हाथ मार दिया तो
जलेबी बढ़िया था, जलेबी क्रंची था। अच्छा लेकिन हाँ थोड़ा सा पतला हो जाता उससे। ऑर्डर था तो शना बता चाहता भाई पूछो उनको चाह কাল আচ্ছা ঠিক আছে দেখছি হলো হলো নটা নটা টাকা
नेक्स्ट बुधवार से
কালকে এটা তো 14th লাস্ট স্যাটারডে না রেস্ট ডেটটা রাখতে হবে এই স্যাটারডে 9 রাখি রাখি নাও নাও কেন ঠিক আছে কালেকশনে খাবার একটু মিশিয়ে আর সাথে খাওয়া যাও যাও কত লাগাবো ভালো কথা নয় প্রবলেম তো ভালো কথা নয় এই লোক যে ভাষাটা বলে সেই ওটার জন্য তো ওয়েট করে আছি আবার আবার সেই বেঁচেছে এক্সট্রা আছে
আমি কাটা ফল খাই
সারা জীবন টিফিনে কাটা ফল গেলে হঠাৎ করে যেটা কাটা ফল খাবো না
दे रहा पठा और लास्ट
লাস্টে মুখ করে চোখ এটা খাও মুখ করে চোখ
হবে না
আমাকে যা বলতে বলেছে আমাকে তো বলতে হবে, আমি ওখানে বসি দাদা।
ক্লিন চিট নিয়ে চলে ক্লিন চিট নিয়ে চলে গেছে নির্দোষ মাসুম
জল
আগে বুধবার খাইয়েছিল তো দুটো বুধবার খাইয়েছে আমি বলেছিলাম তোমাকে পরপর দু বুধবার খাওয়াবে দেখো তুই খাইয়ে দে সত্যি ভাই
ज्यादा देर यहाँ बैठेगा ना तब कल
क्या नहीं कर इधर आई हो जाए মানুষকে বলছি আমি আবার কলেজ করে তুমি নিয়ে এসো হতেই পারে হতেই পারে না বিশ্বাসই করছে না তুমি যাও ডাকছিল হ্যাঁ সেটা
My Lordship, my senior advocate Nilati Bhattacharya is appearing
I'm
virtually.
Yes, sir.
But this pertains to fixation of the grade pay from 1700 to 1800. 100 rupees less grade pay has been assigned to me. If my lord may kindly takes the appointment letter at page 14. But this is a letter of appointment issued on 11th of December 2009. If my lord may kindly comes to page 14 of the writ petition. My name has been given, the name of the petitioner. The present posting, it has been given an arm guard, cash, left hand side top, third line. Posting at head office cash. But thereafter kindly comes to paragraph 2. You will be in the pay scale of 4,900 to 16,200 plus grade pay 1,700 in the pay band 1. But this, my humble submission before Lordship, it will be 1800. That 1,700 has been erroneously given. That will be 1,800. This is my prayer before Lordship. I showed to your Lordship why it will be 1,800. Kindly take note that the pay scale is 4,900 to 16,200.
What did they say?
My lord, our point is it is a question of interpolation, my lord. Kindly take para 7 of my report of the affidavit. He has presented fabricated documents. That is the annexure which has been annexed in the writ is not the correct annexure. Kindly see para 7 and then page 35. Para 7 at page 5 and the annexure is at page 35, the correct one.
$800 to, is it 1,800 or 800?
My lord, if you come to page 31, my lord, page 35, my lord, 35.
Yes, armed guard.
Yes, my lord.
Is it 800? It's 800 to 120.
800 to 1265 and then 260055 to 4175. Now, if you see, this is the correct annexure, my lord. If you take the writ petition, if you take page number 20, my lord, the one which he has annexed.
Yes.
It is 800 1265 2700 4400, my lord. So what we are saying is this, as per para 7, that this is an interpolation, my lord, which has been done. The correct one is at page 35 of our report, my lord. And therefore, he is not entitled to any. $1,800 is misconceived, my lord.
So that 1,700 is the right one, the correct one.
Yes, my lord. Because as per 2000 memo, it has been fixed at that, my lord. As per ROPA 2009, it was fixed at 1,700. That is a
So
page.
you had prepared it according to this West Bengal Service Revision of
Yes,
Pay
my
and
lord.
Allowance rules.
Yes, my lord. Yes, my lord.
Was notified.
My lord, this is at. I'll take page 51, my lord. 51 is as per the notification, my lord. Page 51 of my report, my lord, the first entry.
So apart from this petitioner, how many others were also entitled to it?
This I'll have to check.
Whether anybody else confronted this?
Well, this I'll have to take instructions then, my lord.
You come up with that report, sir? How many were entitled to receive the
if any, my lord, if any,
transfer?
yes.
And if any other person had come up with the same prayer?
My lord.
Because it cannot be exclusive to him only. There must be other persons, if at all posted in the same rank, to have been aggrieved.
My lord, I'll do that. I'll do that, my lord. I'll do that.
May I make a humble submission before? What is the question of interpolation has been raised before the earlier coordinator.
So let them file the report.
But I have brought the entire fourth pay commission report. I will be handing over this to before your lordship. The
My lord,
extract
in his
from,
affidavit in reply
extract
also
from
he
this
said
has been
so.
annexed to the writ petition. And I will show how the 4 STUs, the armed guard, watchman, security or sentry, they have been placed in the similar footing. There was an anomaly in 3rd pay commission. It was regularized in the 4th pay commission. There was a recommendation that those watchman, sentry, security guard, whatever they may be called into, they will be placed in 2nd clause of the pay band 1.
So you are on 2 issues. Number 1, you said it would, instead of 1700, it should be 1800. Now, when I have asked them,
Yes, my
they
lord.
said that there has been an interpolation, right? Yours
And he's
is
silent
incorrect.
on this. And he's silent on this. my lord.
Is incorrect. So let them place, because you are not the only armed guard. There must have been several others. Whether those people also challenge this or not needs to be seen.
Yes,
Now you are coming to the
Yes,
second aspect of pay band or fixation.
Yeah, that is the pay band. 1700, that's been given is the pay band.
If that be the pay band, then it is not to be applicable only to you.
Absolutely.
The others will also be there.
My lord.
So let them find out whether others are also similarly aggrieved like you or not.
My lord.
We need to, when one issue has been raised, challenging your truthfulness, let us find the sanctity to that.
But I am only before your lordship that they.
My lord, only one thing, what he is raising at this point of time, the second issue, it is not there in the prayers also, neither in the averments also.
Fair enough. You place that.
I'll place the report, my lord. I'll place the report.
For the submission of learned advocate representing the petitioner as well as the respondents, learned advocate representing the respondent corporation is to place a report in the form of an affidavit stating as to whether other
Similarly placed.
employees recruited as armed guard in similar position as that of the instant petitioner challenged the pay band to the extent of 1700 as claimed by the petitioner, contrary to a sum of rupees 1800 which has been mentioned in the writ petition. Next date be fixed on 12th of September for filing the report as aforesaid. Next.
For hearing item number 2. Appearing on behalf of the respondent number 229.
Now I appear on behalf of the respondent number 1, Coal India Limited.
Petitioner is not here.
Recorded din tarafı. Now, on the last occasion, it was restored.
Yes. Now
The order of dismissal was
now
called.
disappearing.
Ashun. None appeared to represent the petitioner after the restoration of the instant writ petition by the order dated 22nd of May 2025. The learned advocate representing the respondent. ECL, sir.
Yes, 229, my lord. And my
respondent number 1, Coal India Limited.
Respondent number 1, respondent number 229 are present. Let the matter be adjourned for the day as last chance. Next.
Item number 3.
But I beg to appear on behalf of the petitioner. This is my application
I'm
for
appearing for
compassionate
the
abandonment
respondent.
in a dying harness case. My lord, my father died on 25th of October 2012. And immediately thereafter, I made an application for compassionate appointment on 30th of October 2012. But no objection was given by the other legal heirs. There was 2 marriages at the instance of my father. The legal heirs, apart from me, I've been the elder son of the first out of the first marriage. The other legal heirs have given NOC in my favor. The second wife has also given NOC in my favor. No objection in my favor. But the application for compassionate appointment was made within time, that is within 5 days from the date of the death of the deceased employee. My lord, thereafter, several litigation was carried out for the disbursement of the retiral benefits of my father. My lord, there's a scheme of the West Bengal Transport Corporation, previously Calcutta Tramways Company, that the son is entitled to get the compassionate appointment on the death of the deceased employee. My lord, there was several appointments given in the following that particular scheme. But now my application has been rejected only on the ground that in my application for compassionate appointment, I have never mentioned whether I have been residing at the time of death with my father or not. Only on that ground, this has been rejected. My lord, may kindly takes the scheme first, page 32. But this is the scheme.
The pleadings were completed.
Yes, my lord, opposition reply. Yes, opposition reply has been filed. Now, I have made an application for production of the record, my lord, that is, my lord, perhaps GA number 1 that I have served. That is relating to the submission that I have made before the inquiry officer relating to the hearing that has been taken pursuant to my application for compassionate appointment. They have called me for an hearing. I have made my submissions and that has been noted. But that I'm seeking direction for production because they have said that I have been working in a grill factory. But my specific instruction that I have never made such averment before the concerned authority. For that reason, I have made an application for production of the report.
So you have received the copy of the
Yes.
GA?
Yes, my lord, I have received it, my lord. I have a very short submission to make in this matter, my lord. What scheme he is referring to has been subsequently cancelled by the Ministry of the Department of Finance and the Transport Department, my lord. As of now, there is no scheme pending, my lord, and no appointments have been given, my lord.
Have you taken this point in your affidavit?
My lord, we have not taken. That is why I would like to file a supplementary report to my this petition, my lord, bringing in light those facts, my lord.
Supplementary report, or you want to file an exception to the GA?
But I can file an exception to the GA also. I can bring it on record by that also. Or I may file a supplementary report as the court may deem fit, my lord.
Ashun. The learned advocate representing the respondent corporation seeks permission to file a supplementary affidavit stating further developments with regard to the contentions of the petitioner in the instant writ petition, as well as addressing the issues raised by the petitioner in GA 1 by 2025. And the same is allowed. Next date be fixed on the earlier matter where both of you are there.
12th of September. Your lordship has kept it 12th of September. Permit me to take an exception to the supplementary report that
let them file. Next.
But this is my writ petition rejecting my application for
next din. Yes.
Rejecting my application for equal pay for equal work. But this is the 4th round of litigation. But I have been appointed as a maintenance staff in Calcutta Tramways Company. Way back in the year 31st of August 2010. I was being directed by the OSD, Law and Claims, to operate as a telephone mistri, in addition to my work as a maintenance staff. There's a written order. Pursuant to that, I have discharged my entire time in the promotional post. That is appointed maintenance staff, permitted to work as a telephone mistri. There were several work orders were given to me. Those work orders I have carried out. I made an application that you give me the difference of pay or you give me the promotion. They denied both. The first petition was taken out by the coordinate bench on rejection of my application, which your lordship will get at page 21. That is 1st September 2016, passed by the Honorable Coordinate Bench.
Yes.
The petitioner was appointed by the respondent CTC Limited on 31st August 2010 as a maintenance staff. The appointment letter mentions the petitioner's qualification as Madhyamik. It appears that the subsequently petitioner has acquired further qualification, the technical qualification for the purpose of telephone mystery. The short grievance of the petitioner is that although he was appointed as a maintenance staff, he was made to discharge the duties of a telephone mystery which is a higher post. The telephone mystery is entitled to higher pay than the maintenance staff. The petitioner has produced before this court a bunch of work orders numbering almost 200.
What was the opinion of the managing director?
Thereafter, the managing director passed an order at page 28. This order is very relevant because the court has made a finding to that effect. If I may be permitted to place the finding on only the finding page 22. Page 22, if my lord may kindly comes to once.
I've seen that. You come to page
Yes.
28.
Page 28. Kindly see the last but 3 paragraphs. May I place it? On perusal, it is found that the petitioner claimed promotion to the post of telephone mystery. It was also found that the petitioner Parvez Khan has been actually holding the post of maintenance staff by later date such and such. He has been transferred to the central department head office from the store, and he was asked to utilize his service for repairing job of the telephone.
Thus, considering all the points,
Considering all points as above, it appears that the petitioner will be entitled to get promotion as telephone mystery from the post of maintenance staff, which he belongs at present, when promotional scope of the company for the promotion to the post of telephone mystery will arise and will be approved by the board. The above matter is accordingly disposed of. So my prayer that either you give promotion or you give the difference of pay. So far as the difference of pay is concerned, that has nothing been touched. So this point they have taken in or written affidavit in opposition that this order operates as a res judicata, because after I have been given a promotion afterwards, because there was a promotional advertisement being made. I appeared, I was given promotion. But so far as the area of difference of pay for the time I have rendered,
when promotional scope of the company for the promotion to the post of telephone mystery
will arise, will approve by the board. The matter is
Yes, when
accordingly.
did it arise?
Yes, thereafter I was being given
The
promotion.
next page, my lord.
When did it arise?
Kindly see my next page, 20th of April 2017. Next page. There was an advertisement of 21st December 2016. Your application for the promotion to the post of auto telephone mystery and subsequent trade test and interview, you have been selected for the promotion to the post of auto telephone mystery. You are hereby promoted to the post of auto telephone mystery in the pay scale of 5,400 to 25,200
from 1/5/2017.
From 1/5/2017. So I have been working, discharging the post to the work that is been assigned to the auto telephone mystery, although I was a maintenance staff from the date of my appointment up to 1st of May 2017. So I claimed area difference of pay of the two scales.
What is the date of your promotion?
Date of promotion 20th of April. 20th of April is a notification given effect from 1st of May 2017.
And you are claiming your promotion from a back date?
No. Equal pay for equal work. If I have been made to render services for the post which I have not been appointed, and the law says that if you have been made to discharge, and there is no denial to that effect, that is the observation made by the earlier coordinate benches. That was why I was kindly referring to your lordship at page 22. If the order of the honorable coordinate bench at the last paragraph of page 22. The court is convinced that I have rendered service. The wording is in this way, my lord. If my lord may kindly peruse the page 22 once, last paragraph.
No, in this report itself, it's there.
Yes, that is there. But the observation of the court is that court
Sir,
is
you come to this paragraph on perusal, it is found that the petitioner claimed promotion to the post of telephone mystery. It was also found that the petitioner Parvez Khan has been actually holding the post of maintenance staff by letter number such and such. As per letter number such and such, he was transferred to central department from OH&C store department and was asked to utilize his service for the repairing job of telephone and other handsets under the telecommunication department as and when required. So you are admitting his services?
My lord, why am I admitting, my lord? Because when he was appointed...
When you are admitting his services, don't you think that he should be equally paid for it?
My lord, the terms of service, his appointment states that he may be transferred or he may be made to work any point at any position which the company decides. He works there, my lord. Now, if you come to the order passed by the coordinate bench, the coordinate bench, after holding this, he says, gives the opportunity to the MD to decide on the representation, my lord. The MD,
That I have seen.
The MD decides on the representation, my lord. Subsequently, he gets promoted. He works there for 1 year, and then he makes another representation asking for back wages, my lord.
So did the coordinate bench direct for consideration of back wages, if any?
My lord, kindly see page 23. Allow me to read from page 23 onwards of the writ petition, my lord. In view of the aforesaid, I am of the opinion the matter should be
It is
remanded.
needless to say that the managing director, being the highest authority of the respondent company,
Yes.
is expected to deal with the case of the petitioner sympathetically and ensure that the petitioner gets his lawful dues insofar as his
Posting and
posting and
emoluments are concerned.
emoluments are concerned, commensurate with his qualification and the service that
In fact, renders.
renders.
Yes, well, then let's come to
The order dated such and such is
the
set
matter
aside.
is remanded back to the managing director of the respondent company is aforesaid, so and so on. So therefore, the
No,
court,
he is on this particular sentence that the petitioner gets his lawful dues insofar as his posting and emoluments are concerned, commensurate with his qualification. Apart from the qualification, more on the service that he in fact renders.
Yes, my lord.
Yes. Yes.
My lord, thus the court delegates his responsibility to the managing director as a persona designator, my lord. And the court tells the managing director that as a persona designator, you decide on the issue, my lord. The managing director, in all fairness, after hearing him, states sympathetically, he says that yes, you have been working, but you are only eligible for promotion as and when the advertisement comes, which comes at a subsequent date, and he is given a promotion, my lord. Now, just because he has been working there, how can it be that he will be paid for it when he was appointed as a maintenance worker, my lord? As a persona designator, the MD has already exercised his capacity with what the court has given him. He has seen it sympathetically and he has said that we will consider you when the next promotion, when the notification comes. The notification comes and he...
This is only your issue?
Yes, ma'am. The issue was again was traversed by the order of the coordinate bench at page 33. This order was under challenge. Subsequent to my promotion, I made further representation at page 30 because I was being denied promotion, but there is no order being passed or denial of my areas of difference of pay.
This he makes
Now,
after 1 year of working.
After I been promoted, I made a fresh representation that was being dealt with in the second writ petition at page 33. The coordinate bench of co-equal strength also came to the same finding that he is entitled to. Kindly come to my lord page 33, last paragraph.
Yes.
At page 35.
Last paragraph.
Give me the exact page number.
35, my lord. I'm sorry, my lord. 35, second paragraph. It appears that, may I place it? It appears that though the petitioner was engaged in the post of maintenance staff, but his service was actually utilized for the repair of job and telephone and other handsets. So there is a concurrent finding of the two honorable coordinate benches of co-equal strength, that in fact I have rendered service. And the court directs that managing director is accordingly directed to consider the prayer of the petitioner in accordance with the rules and guidelines of the company within a period of 6 weeks and come to a conclusive finding with regard to the nature.
Very intelligently left out the last paragraph.
Very well, I'm placing. Be that as it may, it is for the court to take a decision whether the service of the petitioner was actually
utilized. It is not for the court.
It is not for the court to take a decision whether the service of the petitioner was actually utilized as a maintenance staff or that of a telephone mystery. It may be that the maintenance staff also looks after and performs the work of telephone repair. It is for the company to look into the matter and conclusively decide as to whether the service of the petitioner was actually utilized and that of the telephone mystery or not. The managing director of the company is accordingly directed to consider the prayer of the petitioner in accordance with the rules, guidelines of the company within a period of 6 weeks and come to a conclusive finding that with regard to the nature of the work performed by the petitioner prior to his promotion, if the managing director is of the opinion that the petitioner was made to work as a telephone mystery, then steps shall be taken by the said authority to release the differential pay up to the petitioner within a period of 10 weeks from the date of taking of the decision in this matter. But that was been disposed of, and subsequently I appeared before the managing director, submitted my needed notes of submission with all the works order about 200 in nature, and those were been annexed with the affidavit in reply also.
Okay. Heard the submission of learned advocate representing the petitioner as well as the respondents. Let the matter be fixed on 12th of September for orders. Next.
Much obliged.
A very innocuous prayer, my lord. Identical matter has been disposed of. It is relates to interest on differential of pay under ROPA 1998. Several coordinate benches have passed an order. The last of the order I am handing over to your lordship with the necessary incorporations. The ROPA 1998 interest, my lord, my friend knows where. Order of Justice Mukherjee.
Order, my lord, is mistake on my part only.
You concede to this?
No, my lord. In this
concede to this matter?
No, my lord. There's a wrong recording, my lord. It's a mistake on my part. The affidavit has to be filed, my lord. Kindly.
In this matter?
Yes, my lord. If liberty may be kindly given, it's a mistake on my part, my lord.
You mean to say in item number 5?
Yes, Pushpen Roy versus State of West Bengal, my lord. In your 10th April order, my lord.
He says that it has been already decided by a coordinate bench. Why don't you go through the order? And then...
that has been annexed with the writ petition. Order which I have handed over to your lordship is the part of the annexure.
So you go through the writ petition once and come back? So why compound the issue? If it has been decided, we can also follow that.
Yes, my lord.
Heard the submission of learned advocates representing both the parties. Next date we fixed on 8th of August. By that time, you go through the order and...
Yes, my lord.
And then you tell me what it is. Next.
Much obliged.
I'm getting...
I am for the petitioner, my lord, led by Mr. Mojumdar. In this matter, my lord, as per your lordship's direction, we have filed a supplementary affidavit disclosing the position of seniority. This matter relates to the prayer of the petitioners for stepping up of pay. The seniors to the petitioners, their pay was stepped up due to the induction of 2 junior officers in the same cadre. They came from outside, they came from the dock labor board. They were receiving a higher pay. So the seniors who were senior to the petitioners, their pay was stepped up. The petitioners' pay was not stepped up. I have disclosed the scenario in the supplementary affidavit. Lordship kindly takes up the affidavit, my lord.
Supplementary affidavit supplementary affidavit copy kothay?
The affidavit in terms of order dated 18/3/2025.
Yes.
Kindly comes to page 9, my lord. That is an extra chart. Are officers who were senior to the writ petitioners. 6 to 9 are the writ petitioners, and 10, 11, and 12, these are the persons who were inducted from the dock labor board to the Holdia dock complex. My lord, they were inducted. Kindly sees, my lord, the name Sudip Kumar Mondol, that's serial number 10 at page 10.
Yes.
He was inducted in the class 1 grade on 12th of May 2004.
Yes.
My lord, the petitioners were inducted in the class 1 grade, my lord, on 3rd of January 2003,
Yes.
and the others, my lord, from 1 to 5, they were inducted much prior, from 99 and from 98 to 2000, 1 to serial number 5. Now, my lord, due to this induction of the serial number 10, 11, and 12 into the pool of class 1 officers in the respondent port, my lord, they started receiving the basic of 11100. I've pointed out in the chart. My lord, 12/5/2004 with basic of 11100. This is much higher to the basic pay of the petitioners, that is 9100. But the petitioners were inducted at a prior date into the pool of class 1 officer.
So can you equate your status with them who had been?
I am paying stepping up of pay, because, my lord, the seniors who were also in the same pool, who were who has been inducted as a class 1 officer much prior to the petitioner, as well as these 3 officers who came in from.
You are seeking proportionate enhancement.
My lord, I am paying stepping up of pay, which has been granted to serial number 1 to 5, but not to the petitioners. They are differentiating the.
But then there must be a difference in the dates. Dates of promotion must be different, because you were your inception in the service was much later than the ones who had already been in service being accorded the stepping up.
Well, the petition, the 1 to 5, serial number 1 to 5 are much senior to me. They were the induction is much prior. We came up thereafter, we were inducted, and much after that, these 3 officers from outside came into the same pool of class 1 officers, the last 3 serials.
Yes, 10, 11, 12.
Yes. With the introduction of these 3 officers, the pay of the 1 to 5 serial number were enhanced, but not the serial number 6 to 9, that is the petitioner. So if the juniors are getting higher pay, and
so why was this done selectively, sir?
No, Milord, possibly, Milord, with deepest respect, Milord, he has completed, Milord.
No. Anyway,
well, they say that we are not directly recruited, but we are promoted. That is why we will not get this benefit. That is their stand. Well, first of all,
is there any rule?
The rule says selection, not promotion. I shall show the rule.
Same cadre?
Yes.
Sources are different.
The juniors came from outside.
You said there is a difference between in-service and direct recruitment, isn't it?
Yes.
So that means what? Sources are different. Ones who had been in service and the others who had been directly recruited. So is it that based on this method in which you got your entry into the service, there has been a discrimination?
Yes, they say that this we are promoted. We are the promotees within the HDC. That is why we are not eligible to the stepping up of pay. But my first submission, my lord, is that, my lord, even if I am a promotee and not a directly selected candidate, once the method of induction may be different, but once they form a uniform pool, they come from the different. One may be promotee, one may be directly recruited. But when they are serving at the same cadre, and a junior cannot get higher pay than the senior. If they are at the same post, they are holding the same post, how can a junior officer who has been inducted much later, maybe he was from outside, how can he get more pay than the senior officer? And secondly, my lord, kindly see the rule.
Same cadre.
In the same cadre.
What about the services rendered by them? Years of service were the same?
They came into this establishment in 2004 itself.
Sir, who were there in service, as well as who came from outside directly to the same post? There must have been a difference in services, number of years of services.
Can you kindly see the chart once again? I have tried to explain it, my lord.
So you said Priyobroto Roy. No, they joined in HDC at on 3rd of January 2003.
But we were inducted in the class 1 pool on 3rd of January 2003. We were in HDC from the beginning.
That's exactly what I'm asking you, sir. You had been in service,
Yes.
right?
Yes.
So
But we were promoted in 97 to in 87 to 92. This was our range within which all the petitioners were appointed in initial appointment.
10, 11, and 12,
I know.
they came into service on 12th of May 2004.
Yes.
Yes, you mean to say that you had already been in service, right? Thereafter, you continued, given promotion, and these people were granted stepping up on
12th of May 2004 itself, when they came into service.
No, this is about 10, 11, 12.
Yes.
So they were given stepping up.
They were not given stepping up. These are the officers whose pay was enhanced and came into the service. Stepping up was given to 1 to 5 to match the pay of 10, 11, 12.
Their basic at the level of inception were more than yours.
My lord.
After rendering a considerable years of service.
My lord. Because their basic was more, my lord, 1 to 5 was given stepping up to match the match, but we were not granted. Saying that 1 to 5 were directly recruitee and they were already in the class 1 pool, but you were promotees. So they are different. They are creating a difference between 1 to 5.
There is any rule?
My lord, kindly sees, my lord. Kindly comes to page 22 of the writ petition, my lord.
Yes.
Well, the relevant portion is at page 24. The first serial, assistant engineer. Well, the method as in column number 5 says selection.
Yes.
So there is no scope of in promotion. This has to be selection. We were in-house candidate, but we were selected upon a proper method of recruitment. Well, we were selected after selection, sitting for the selection exercise.
So you come to column number 10.
My lord.
In the same page.
Yes.
By adjustment of management trainees and or by direct recruitment, 1/3 of the vacancies, however, may be filled by promotion from the rank of junior assistant engineer group 1, having a minimum regular service of 3 years in that post, failing which by direct recruitment. So this is restricted only to the vacancies concerned, right? Anything else, sir?
And kindly comes to page, my lord. Kindly comes to page 43 once. Now, this is a document issued by the general manager. In the second paragraph, in view of the above, the case of selection of Sri Ashok Kumar Das and A. Adgiri.
Case, appointment in a post by promotion should normally imply assumption of higher duties and responsibilities. Whereas in case of direct recruitment, since it is an appointment in a new post, normally at the time of fixation of pay, consideration of assuming higher duties and responsibilities does not come into the picture. Therefore, the pay has to be fixed by a different rule than that of fixation in a case of promotion. Hence, it appears that the instant case may be seen in terms of provisions number such and such. Hence, it may also be seen whether officers whose pay fix at under FR such and such can be compared with the officers directly recruited. Another similar application may review the matter afresh. Then what happened?
We were not granted stepping up.
But they did contemplate on it.
Yes, and kindly considers the just the paragraph, just the previous paragraph, paragraph 2. He says, my lord, in view of the above, the case of selection of Ashok Kumar Das and
Can it be considered as it was a case akin to selection by as a direct recruit?
my lord.
Anomaly in pay. So what happened thereafter?
Thereafter, my lord, my lord, kindly comes to page 53 once, my lord. I shall show the. My lord, the names which I pointed out on page, the earlier page, my lord, paragraph 2, they are the petitioners. My lord, page 53, my lord, the last paragraph says, my lord.
Maybe stepped up to the level
Yes.
of junior.
So the recommendations were there.
Then what?
Not granted.
Till date.
Yes. Still not granted. That is our grievance.
You had come up in any other writ petition before the court?
No, this is the writ petitions, my lord.
In this, there was an earlier direction in this particular writ petition.
No.
No, you come to page 53.
Yes.
In consideration of all above conclusion and direction of Honorable High Court in Kolkata in case of Pradesh Kumar Ghosh and others versus Kolkata Port Trust regarding quashing and set aside of such and reconsider the petitioner's pairs afresh in the light of observations of Honorable Supreme Court in case of Gurcharan Singh such, the undersigned would like to recommend that pray of C. A.K. Das, S.K. Giri, A. Adgiri and P.
Roy Mahapatra.
Yes, be similarly as well as similarly placed officers employees may be stepped up to the level of juniors as per option number 2.
Yes.
So
Yes,
this
so
was done.
this was a different matter. We were not there in that matter, but those petitioners were different. But
those petitioners were different, but are you similarly placed with those petitioners?
Yes, I am similarly placed, my lord. And this is the recommendation of the management itself.
With regard to those petitioners
Yes.
who were probably the party in that writ petition.
No, as well as kindly the last two lines, my lord. The undersigned would be to recommend these are my clients, my lord. A.K. Das, K. Giri, A. Adgiri, and Mr. Roy Mahapatra.
So that is exactly what I am asking you, since in consonance with the earlier writ petition, the petitioners therein had been granted step up to be at par with the junior officers. There had been a subsequent consideration of your case also for recommendation. What was the result?
But the result is, my lord, we were not recommended for step up. That is why we have filed this writ petition.
But
this recommendation is there, but ultimately it was not granted.
What is the reason? They did not cite any reason.
The reason is that, my lord, we are not directly recruited. They say that you are promoting. But I say, my lord, let us assume that I am promoting and not directly recruiting. But when I entered the pool of class 1 officer, the method of recruitment may be different. But when 2 officers entered the pool, the junior cannot be getting.
That is why I asked you, sir. The source may be the different.
Yes.
But the cadre is the same.
Yes.
So, is there any rule? Only on the point of entry into the service, or to be more specific, entry into the distinct cadre from 2 different sources, either from the service or through direct recruitment, they can create a difference.
No, I humbly submit, there is nothing like that. They are trying to make one.
So if they are trying to make, they have to place the rule.
Milord, first of all, Milord, the page 26 of your lordship's brief. Writ petition. My lord, got it? 2-6.
Yes.
Now, my lord, these are the petitioners 1, 2, 3, 4, subject to correction, as approved by the deputy chairman of the following supervisor, such and such, the scale of pay, such and such. These names were given hereunder. The promotion of the are to be promoted, the scale up are to be promoted to the post of assistant engineer in the scale of pay. Names are there. These names are given hereunder. The promotion of the above mentioned employees will, however, be an officiating basis in the post of assistant engineer and will be effective from the actual date of their assumption of duties and responsibilities in the said higher post, such promotion will abide by the sanction of the ministry in the matter of procedure of filling of the post of department. Got it? Now, my lord, my specific instruction that they do not belong to the same cadre. First, that is the specific query from my lord, if I have correctly understood my lord's mind. Now, my lord, the private respondents were direct recruitees and appointed by direct recruitment in the year 1999 in the post of assistant engineer. On the other hand, my learned esteemed friends client were promoted to the post of assistant engineer on the basis of officiating base in 2003. Here is also the difference. The private respondents against whom the allegation, that is my specific instruction, my lord, that has been given by the Port Trust. And now, my lord, my answer to the query, the paragraph 9 of the writ petition, 99 is the page, my lord, they made a representation. That has not been considered. Today, my lord, the question is whether equals have been treated unequally. If that is so, my lord, first of all, he has to show, my lord, the discrimination has been meted out between the same persons, my lord, belonging to same cadre. Number one, my specific instruction they do not belong to. And
so they belong to which cadre?
Cadre 3 and cadre 2. There is a cadre 3 and cadre 2. It was specifically said, my lord, that in the memo, the 26th appointment is a, my lord, your lordship knows, my lord, it is, my lord, maybe a tiring repetition. 3 mode of appointment: transfer, promotion, and direct. He said that I'm a promotion.
No, you tell me the grade to
kindly
which
sees my
these-
paragraph.
Tell me the grade to which these.
That is why, my lord, let us take my lord's attention to paragraph 6, 7, and 8 of my EO. Now, my lord, kindly, my lord, I start from, my lord, page 4, paragraph 5, subpara, the second para. Page, my lord, page 4, opposition. Yes. 26 I have shown. Page. Kindly see, my lord, page 4. Yes. In this regard, I state that the appointment of the officers of the Calcutta Dock Labour Board was treated as a redeployment by transfer basis CDLB to Haldia Block Complex, in short HDC administration, and applied for the principle of CCS redeployment surplus staff rules 1990. While considering the appointment of CDLB officers, Section 5 of the said rules dealing with the termination of placement stipulates that as possible a surplus employee shall, subject to his suitability, be redeployed in a post carrying a pay scale matching his current pay scale. It further states that whereas suitable vacancy in a post carrying matching scale of pay is not available, the surplus employee may be redeployed in a post carrying a non-matching pay scale subject to certain condition. A surplus employee who is sponsored or nominated against a post having a pay scale with a higher maximum, he should either have the qualification as prescribed for appointment to the post by direct recruitment or by transfer should have been successfully performing in his parent.
Paragraph 6 in page number 5, you stated that in this regard deny and dispute that the petitioners are in the class 1 post of the permanent employees.
Since they are not similarly placed with the officer as stated by the petition under paragraph 9.
They must also belong to a certain class 1, 2, 3.
Now, my lord, the
so to which class do
my lord,
they
that
belong?
is that is, my lord, in the my lord, page 26, my lord, they belong to the class 3. They said it is a class 3.
Page 26 of the
No,
petition.
my lord, they said, my lord, they belong to class 3 officers. They said, I said, first of all, my lord, kindly, my lord, let us, page 7 of the writ petition, they admitted. Your lordship is asking us question whether they belong to the class 1 officer or class 2 or class 3.
Yes. Page 7.
Page 7, my lord, kindly take explain. Paragraph 7, the last part, before paragraph 8.
At the time of issuance of the invitation application, the petitioner was hold.
The recruitment, seniority and promotion 1985 did not permit promotion from a class 3 post to class 1 post, and accordingly your petitioners were directly recruited in class 1 post, not by way of promotion from feeder post. That is what they are saying. So they are
then what is the letter, page 26 I have shown?
So you said that they were not class 1.
No, I said they said they class 3 at the time, my lord. Kindly sees the feeder post. And what is this 26? Page 26.
In page 7 of their writ petition, they have stated that they were appointed directly to class 1 post. That is what they have said.
Milord, first of all, Milord, page 26, Milord, they themselves, the order says this is they relied on. As approved by the deputy chairman supervision, the engineer scale of pay such and such, the terms at the promotion of the above mentioned employees will, however, be an officiating basis.
But here, it doesn't mention the class.
And kindly says this is dependent on the sanction of the ministry.
So did you
No, no.
You did not.
No, and that is why they made a representation at page 99 at the outset. They submitted. They on the last occasion
who would have been in a better position to obtain the sanction of the ministry?
The ministry. That is the ministry formula. I am not the ministry. I am the respondent.
So you, unless and until you recommend their stance to the ministry, how can
Milord, recommendation is also not binding upon the ministry. Ministry has to take a stand, and I said so.
So what have you done to enable the ministry to take?
I cannot enable someone. I can only make a recommendation whether it is made. There is an approval. That is in the condition of the appointment.
What stance have you taken to enable?
I cannot enable someone. I only recommended or forwarded.
Then what happened?
Now, Milord, no response. That is also their case. They are alleging inaction. They said on the last occasion, not in this court, before 25, that they want that this representation at page 99 has to be considered. First of all, they have to, Milord, cross the hurdle that, Milord, they belong to the same cadre. Number one. Number two, Milord, that the recruitment difference.
This was of 2003.
Huh?
This recommendation was of 2003. You just mentioned this. Did you send a formal recommendation to the ministry?
Milord, my instruction, Milord, I cannot travel.
Office order dated 3/1/20.
That was referred to, Milord. This was the reference, Milord, made.
Promotion will abide by the sanction of ministry.
So, Milord, dependent subject to approval.
In the matter of the procedure of filling up of the said post by departmental candidates.
No, Milord, first of all, Milord, the first question that has been answered belong to the same cadre. Second,
no, it has not been answered. Nowhere you have stated that.
Let me, Milord, permit me to read paragraph 6, 7, and 8. Without reading it, how can I demonstrate, Milord? Kindly seize the paragraph 6 of the affidavit. I have 6, 7.
You have said whatever.
No, I have said, Milord, subject to correction, Milord. Kindly seize that the 6th paragraph. I have specifically referred to the memorandum which deals with the cases of senior direct recruitees who were paid the lesser pay than the promoting officer owing to admissibility of 2 guaranteed additional increments over the paid time scale. In this case, the government have stepped up the pay of the senior direct recruitees at par with the drawing the higher pay. On the other hand, I referred a memo, Milord. 1993 memo states that the pre-service training period would count as a duty and increments would be allowed for that pre-service training, as a result of which junior officers were drawing more pay than his senior officers whose training period was not counted for increment. Next, Milord, I said paragraph 8, Milord, which is a detailed discussion. It starts from, Milord, page 7, Milord. Kindly seize. Paragraph 7. I state that the management of the Haldia complex have examined the prayers of the petitioner with due diligence. The document placed by the petitioners contains the views of the various authorities while dealing with the grievances of the petitioner at different points of time. As such, there may be some views purportedly favoring the cause of the petitioner. The said documents obtained by the petitioner also contain strong views against the claim of the petitioner, but very cleverly, those were not mentioned by the petitioner. It is further stated that it is on record that the general manager had actually opined at page 25, annexure P7 to the writ petition. I will take my lord's attention to that. In the present situation, it is advisable that the promoting officer be granted premature increments in the pay scale of such and such, so that their pay is fixed either at par with the CDLB class 1 officer or just above them in the immediate. Similarly, General Manager Finance had opined, as such, the provision of PR 27 is not applicable in the FR it should be FR, I'm sorry, is not applicable in the instant case. Moreover, it is also observed that premature increments can be granted subject to above stated conditionality by the authorities who are competent to create a post. In the instant case, the authority who is competent to create a post is the ministry. In view of the above, it is felt the suggestion of the advocate to step up the pay of the applicants by invocation of FR 27 is justifiable and may not be accepted. is not justifiable and may not be accepted. Stepping up of the pay point of the applicants may invite severe criticism for the government audit, as already happened in earlier cases. Moreover, will also open the floodgate of the claims similarly placed under employees. In view of the above, the undersigned does not concur for granting any increments under FR 27 to the applicants. However, the matter is submitted for administrative consideration. Then, the second paragraph. One officer, Sri S.K. Mondal, had joined Holdia Work Complex as an assistant engineer, now designated as assistant engineer on 12/5/2004. In class 1 scale of pay of rupees such and such, now revised such and such, from the post of assistant engineer class 2 in the scale of such and such, now revised to such and such under CDLB. At the time of joining at HDSC, he was already drawing higher pay at CDLB in comparison to the basic pay of the petitioners who were drawing at the HDC. Moreover, the answer on the petition, on the other hand, were found eligible for the post of assistant RCF upon being found suitable through the prescribed process of selection, and hence promotion of the petitioners were effected with the approval of the administrative authority on the basis of the recommendation of the departmental promotion committee. Accordingly, the petitioners were all promoted to the assistant engineer on 3/1/2003 in the scale of pay from class 3 post to grade 1, erstwhile supervisor in the scale of pay of such and such, pre-revised scale at the time. Their pay was also fixed as per Finance Rule 2022-1, considering that their degree of responsibilities were higher in the new post. It is further stated that removal of anomaly by stating up a pay seniors drawing less pay than his junior and promotion senior can only be effected if the following conditions mentioned in rules are fulfilled. Both the junior senior officers should belong to the same cadre and the post in which they have been promoted and appointed should be identical and the same cadre. The scale of pay of the lower and higher post in which they are entitled to draw pay should be identical. The anomaly should be directly as a result of the application as if ever in the lower post, and the junior officers draws from time to time a higher rate of pay than the senior by virtue of grant of advance increment. The above provisions will not be invoked to step up the pay of the senior officer. Now, in the instant case, junior and the concerned senior did not belong to the same cover, since the junior belonged to class 2 cadre at CDLB, while the concerned seniors belong to class 3 at cadre at HDC. Hence, the condition of G22 FR22 has not been fulfilled.
So, sir, this condition would have been equally applicable to the ones who have been granted step up prior to 2003, the conditions that you have mentioned, the ones who have been given up the step up. That chart that they had given?
The chart is incomplete. It does not convey the entire picture. First of all, it should have been started, with clarity that the person, the date of entry, the mode of recruitment, their date of entry in the service, their officiating basis, and guided by the page 26 of the Appellate petition, that this is the condition of appointment. Now, the question is today, the 99, the representation, it delineates the correct, in a way, partially correct picture that this should be considered and the ministry's approval. Because whatever I have said, it appears from the record. First of applicability of the finance rule, it has to be applicable in the context. I cannot travel beyond the roof. I am under the government. Although I am a salutary body, my birth was given, because of the salutary enactment. Even then, the finance control, the Department of Finance is there. Now, they have waited 1999, the first distribution. 1999 page, it says. Question is, in paragraph 8, 1, 2, 3, why the case has not a case of unique classic example of discrimination. I have made an attempt, assuming not admitting someone XYZ has been conferred benefit. Question is it a case of the petitioner asking a constitutional reasonableness of constitutional court that a negative equality should be implemented? I put this question to myself with humility, even if assuming that somebody has been blessed with some benefits. Question is, he has to establish in an adversarial litigation that his case standing on the same footing as that of the private respondent. If that is absent, the question of the other.
Sir, you rectify the mistake in the charts that they have made.
No, I am required to. Then I shall make a chart, and fill up the incompleteness.
Yes, sir.
All right, or is today your lordship has heard us extensively. permit us to come with a written notice of agreement if there is a cloud of confusion.
Sir, you
No, I
just
got my-
pointed out that the chart is incomplete and it
Which, where is it, Millard? First of all, I put this question, Millard. Kindly do not take me amiss. Millard, your lordship always wanted a clear picture. Now, Millard, your lordship wanted to find out the element of discrimination. Article 14. Very simple. Question is, this chart must show that the persons, Millard, equals have been treated unequal. The question is, where is that morsel of proof? I put this question. Does it indicate, Millard, the entire the contour? It takes us nowhere.
That's why I said, sir, you rectify it, you prepare a proper
My senior
chart.
is here.
Lordship granted them opportunity to file an exception, my lord, to the chart.
Well, I respect his, Millard.
exception
এক মিনিট।
Kindly see his order dated 4th of July.
বলছো কিন্তু ঠিক বলছে। এক মিনিট। ছেড়ে দাও না। না দাঁড়াও দাঁড়াও। একটু দাঁড়াও ওকে বলি। Where is the allegation, the averment I need to deal with this? It's a statement that's showing the chart.
Now, when you have found out that that chart is incomplete,
No, I
which,
said, Millard, that after interaction, Millard, I could not anticipate your lordship's mind. Your lordship has put a very specific, relevant question regarding whether the cadre and the promotional and why it should be equal. Now, Millard, this chart, subject to correction, Millard, it may be my incomplete understanding of the situation. Millard, kindly sees previous service, join such and such. First of all, there is no statement.
yes, you have also correctly pointed out that from this chart, it's not clear or conspicuous.
From the statement also. Statement
So why don't you at your own prepare a proper one which you think is absolutely correct?
But I have
Why are you just on the paragraph?
Your lordship's desire is a comment. কথা বলি না জজ যা বলবে না জজ কাজের কথা বলছে
Not file the exception.
Not exception, chart only.
No, exception to the chart and very cleverly kept silent on it. File it.
The term cleverness, Millard, does not match with my mentor.
Oh, somebody who exudes it in every possible manner.
No, Millard.
Ning.
কি করব কি জজ সাহেবরা বলবে তাই করব
First of all, distinction in cadre that you are stating.
That is, Millard, I tell you, lordship.
Date, promotion, how, everything. The way he has elaborately explained.
Statement বলা আছে, affidavit বলা আছে।
Because he is the one to have pointed out that the chart is incomplete.
If your lordship feels that it is correct, then Millard, I will.
I don't say it is correct or incorrect. It is for you to find out. He placed the chart which he thought is correct. You are saying it is incorrect. So you place the chart which you feel is correct.
Millard, that the affidavit, supplementary affidavit, Millard, as my paragraph 8 of the affidavit in opposition, he has.
You call the officers and get it done.
That is our officer.
You call the officers and get it done.
এটাই করে দিতে
আসুন।
বলছে এই চারটা বলছে
তাহলে ওটা রিপোর্ট না করে যে আমি চারটা ভুল বলেছি
করবে
না
Millard, I said, Millard, this chart, Millard, is not, Millard, commensurating with the affidavit paragraph 8 of this. This is my submission.
Whatever it is.
এটা তো বলতে পারি
They had to
Kindly
file the
record.
exception. In which one?
8th of July. 4th of July.
I am not saying, Millard, that is an incorrect chart. I said, Millard, it
You
does
said incomplete.
I said, Millard, it does not match with the, Millard, my affidavit
But
paragraph.
that is something which you are saying now.
Yes.
Initially you said
And also that is why, according to my perception, kindly record, it is
the
incomplete.
learned heard the submission of learned advocate representing the petitioner as well as the respondents at length. The learned advocate representing the respondent is to prepare a chart with regard to the contentions in paragraph 8 of the affidavit in opposition.
Yes, 678. 678, paragraph 6.
Paragraph 678. The charge is to reflect the date of appointment, comma, the date of promotion, and the cadre to which the present petitioners belong to vis-a-vis the other persons against whom the grievance has been agitated by the petitioners with regard to seniority and gradation of pay.
And cadre.
Cadre I have already stated. Next date we fixed on 16th of September.
আজকে তো 6 তারিখ 6 অগস্ট হ্যাঁ ডিপলি অবলাইজ
Today is the first day when he attended all his matters, 4 in numbers. That too was made to.
My previous experience, Miller, is synonymous with my nightmare, Miller.
ও দেখে আজকে ডেট
In item 24, my lord, I am for the petitioner.
My lord, Mr. M is appearing for the West Bengal State Election Commission and is
Sir, I believe today it would be a bit difficult.
I will take only, my lord, 10 minutes if it suits your lordship to
Because
conclude my argument.
That's true, but
Or if your lordship fix it
tomorrow we'll do it.
tomorrow.
Tomorrow? Yes, sir.
Madam, can it be on day after tomorrow? Madam, I have some difficulty tomorrow. I have to take some medical thing. Can it be day after tomorrow, my lord?
ID.
I am humbly requesting you,
I would
lordship.
not be at Calcutta. So, my lord, Monday.
Your presence is.
They have already gone.
Your juniors to be there.
Yes,
All right, I will try my level best to be here, my lord.
Or maximum 10 minutes.
Sir, I have the entire
Yes.
SMA done. One of the staff got
what is
fell sick. 1 hour was consumed in his.
Let us come back tomorrow at 2.
Come back tomorrow at 2. Okay,
Great.
sir. ওনাদের presence record করে let the matter be adjourned for the day.
My lord, in this matter, I am appealing for response number 6, my lord.
Next.
My lord, I appear for the petitioner. My lord, Mr. Lordship will recollect, my lord. My lord has been pleased, my lord, to engage, my lord, appoint Mr. Amartya Ghosh, my lord, as amicus curiae, my lord. Lord, Mr. Ghosh had some personal difficulty. I had a word with him, my lord. He had fractured his leg, my lord.
Fractured his leg?
Yeah, my lord. Leg, my lord. My lord, if it so commences, if my lord, if the matter may be adjourned for a period of 2 weeks.
Who is appearing for?
Mr. Ghosh, my lord.
Mr. Ghosh is your other side?
Yes, my lord. In fact, my lords have been pleased to appoint him as an amicus, my lord.
But I think I saw him 2-3 days back.
My lord, he was here some time back, but he said his legs were hurting.
It's not, he must not be prepared with this.
My lord, that's what he said, that his leg was hurting. He had a fracture on his leg. So he said that. It's my petition, my lord. I am for the petitioner. My 482.
So I'll fix it on Monday then.
My lord, he requested to keep it after 25th, my lord.
25th of
August, my lord. That's what he said, my lord.
Acha.
I, my lord,
Was submitted by the learned advocate representing the petitioner, that the learned advocate who had been requested to represent the opposite parties, being as an amicus curiae, had been indisposed of. Accordingly, let the matter be fixed on 27th of August.
wait, my lord. Biplab.
In your matter, possibly every endeavor was attempted to get the respondents, but the police could not serve the notice. So nobody appeared. So
But
now
my
it's
lord,
a revisional application, so I requested him.
My lord, lordship will appreciate, my lord. It's a complaint in the nature of a defamation suit, my lord. So, my lord, in my respectful submission, of course, I will be addressing.
It's, I have gone through the matter. It's more of, I should not.
In my respectful submission, my lord, there is nothing defamatory, my lord. It is the petitioner, my lord. Lordship will recollect, my lord. I am Arya Samaj, my lord.
I know, sir. We are running out of time today.
Grateful ones. Grateful.
My lord, I'm for the petitioner, my lord. Mr. Milan Mukherjee is arguing, my lord. He's on legs. My lord, can this be kept next week?
Ask him to be there after he finishes off. Next.
Lordship, I am on behalf of the petitioners, Lordship.
But, on the last occasion, as on 31st July,
this is that paddy matter. Yes.
There has been an order passed by your Lordship, my lord, which reflects, my lord, Lordship was desirous of that the state should be represented, my lord. Today, I have been instructed by learned GP to appear in the matter, my lord.
Yes.
My lord, can I have a copy of the writ petition if my lord?
Because you have to place that police report and.
Yeah, my lord, I don't know anything about the matter. Just now, I have been instructed, my lord, I'll appear.
Have you been engaged?
He asked me to appear. I'll be engaged, my lord. I am the additional government petitioner. I'll be engaged, my lord.
The learned advocate submitted to have been instructed by the learned government pleader to appear on behalf of the state. He is the learned advocate representing the petitioner is to serve a copy of the writ petition along with the annexed documents upon the learned advocate representing the state. None appear to represent respondent numbers.
My lord,
10 and 11.
10 and 11. My lord, I am representing the 10 and 11 led by Mr. Mukherjee.
But Mr. Mukherjee is not there
My lord,
today.
he is on his leg. I am also.
Next.
Lordship, may I submit one thing? Only interim protection, Lordship, to cultivate the
Cannot
land.
be done, sir. This is not the forum. Next date be fixed on 4th of September.
4th of September.
Next.
I'm grateful, my lord.
Yes. Huh? তাড়াতাড়ি তাড়াতাড়ি
Lord, 44, my lord, Mr. Mitra is appearing, my lord. A matter has been called, my lord.
There is a direction to file a supplement. No, report. There is a direction to file a report.
Report, my lord, as to where the posting of the, my lord, petitioner, my lord. This is the report, my lord.
May I get a copy of that?
The report from the report filed by the learned advocate representing the respondent Union of India in compliance with the order dated 19/3/2025 be kept on record. A copy of the same
Has been served, my lord.
be served upon the learned advocate representing the petitioner. Next date be fixed on 22nd of August.
My lord.
Next. $57. 65.
Five.
Asha. None appeared to represent either of the parties on the earlier occasion on 5/8/2025. None appeared to represent the petitioner and the matter was adjourned today as last chance. However, the petitioner as well as the respondents were not represented. No accommodation was sought for. Let the writ petition be dismissed for default. Next.
My lord, I take a short passover. My advocate is on the way. Short passover.
এটা কেন এসেছে রেকর্ডে? না এলে FM একটা আছে না 65? আচ্ছা নেক্সট। None appeared to represent the petitioners. Order dated 1/7/2025 had not been complied with. The instant writ petition had been earlier dismissed, thereafter recalled, thereafter restored. Recalling the order dated 10th of July 2024, wide order dated 2012/2024 passed by the coordinate bench of this court. এটা তার আগেও ডিসমিস হয়েছিল, দু তিনবার ডিসমিস হয়েছে, দুই তিনবার রেস্টোর হয়েছে। The register administration LOM is to serve notice upon the petitioner, petitioner to the concerned police station, intimating the next date of hearing, annexing the orders passed by this court with regard to the writ petition being dismissed and subsequently restored. Next date be fixed on 9th of September. A compliance report to that effect is to be filed. Claim cases.
My lord, item 2.
Yes, you show me your mobile.
So, my lord, item. Mukherjee has
Next. You people should be taken to task.
66, my lord, I appear for the appellant insurance company.
66, I'm applying for claimant respondent. The claim application was filed under section 163 3A of the.
My lord, the brief conspectus of the case, I'm for the insurance company, my lord. Whether the insurance company can be made liable to pay compensation, no fault compensation, to a person who has stepped into the shoes of the owner under section 163A of the Motor Vehicles Act. That is the very, and the law has been settled by the Honorable Supreme Court. I'm carrying all the judgments, Lordship.
Sure. You have filed the paper book today.
Paper book has already been filed, my lord.
I filed.
No, it's already. Check on for the submission of learned advocates presenting of the parties. Next date be fixed on 25th of September for orders. Next.
Deeply obliged.
Yes, my appeal, Lord. My application for noting of majority and correction of names on the appellants. Well, your Lordship very kindly asked me to bring the death birth certificate of the minor claimants. They have got the school certificate. They admit got school. Two were minor, number 2 and 3.
Doctor. Sorry.
In the appeal, in the claim petition, the claimant number 1 was described as Hasne Banu Bawa, whose name was subsequently in the Aadhaar card noted as Hasina Bibi. And number 2, Lord, the minor baby Khatun. She has been taken as baby Khatun, BABY, baby Khatun. And Lord, they were Sabina Khatun. She has been described as
Why
Sebi
did you
Khatun.
file this scan application?
For noting of majority as well as the correction of the names.
Correction?
As well as correction of the names. Paragraph, let's kindly show the paragraph 8.
So then you file a supplementary affidavit with this document. So this document cannot be kept on record like this.
But they have to bring from whom? Well, Aadhaar card I filed, Lord.
You file this in the form of an affidavit. The learned advocate representing the appellant claimants is to file the documents placed before the court in the form of an affidavit. Next date we fixed on 23rd of September.
23rd September.
September, as he's saying, it's far away.
Okay, 23rd September.
Next.
Yes, September.
71, my lord, I am for the respondent claimant. But on last occasion, your lordship directed the appellant insurance company to deposit the rest of the amount of the compensation amount. I don't know, my lord.
Who is representing them?
Mr. Kiran, Kono Kiran Bodhapatya.
Regular?
Yes, my
Appears
lord, yes,
regular? Chanchal,
my lord, on last occasion, I submit that
if they do not, in any case, madam, it still contains an FMAT.
my lord.
So it's not been admitted. So I'll adjourn it for today, and if tomorrow no one appears, I'll ask them
My
to.
lord, one more thing on last occasion, I submit that I want to file an affidavit in respect of Section 5 application. But my
For what?
lordship,
Did you file any cross objection?
no, my lord, no objection in respect of Section 5. I do not file any objection to the Section 5 application.
I can't understand.
Well, I don't want to file any objection to the Section 5 application.
None appear to represent the appellant insurance company. The learned advocate representing respondent 1 to 6 claimants is present. Let the matter be adjourned for the day. Next. I'm appearing.
72 Lordship, I am for the appellant. Lordship, paper book I have served and filed before your Lordship, and Lordship fixed the matter today for hearing list. But Lordship, there is the appeal against the Lordship, the order of dismissal. The learned tribunal dismissed the appeal on the question. There is feel some doubt on the evidence of the as the evidence as was by the parties in the proceedings. So Lordship, kindly come to the judgment, so I can place the judgment on that part where the learned tribunal doubt that and dismiss the claim application.
Which page?
Lordship, kindly come to page. That is the delay lodging FIR 14 days. And Lordship, kindly.
I asked you which page?
Yes, Lordship, page I am where the Lordship tribunal, Lordship, kindly. Lordship, page judgment page start from Lordship page 34 of my paper book.
Which is the relevant portion you want to show?
Relevant portion, Lordship, kindly page, Lordship, the 37, last paragraph. It is the claim of the PW1 corroborated by PW3 after the accident. The victim was shifted to Borga Sadgram Hospital, thereafter shifted to Kalla Hospital. No medical person produced in support of the claim PW1 was treated at Borga Sadgram Hospital in connection with the accident injury. Postmortem also marked the exhibit 6, which reveals that the victim was found to have been sustained the lateral injury over the head. The exhibit 6 does not disclose the injury was caused to the victim due to the road traffic accident. Injury report to the Borga Hospital, which was alleged taken immediately after the accident, would have revealed as to whether the injury was caused by the victim by the RTA by any of or by any other means. The petitioner have withheld such injury report and have not given any explanation as to whether the such injury has not been produced. In the serious doubt on the evidence of PW1 and 3, the victim sustained injury as a result of RTA. Exhibit 6 posterior reports lays down the cause of death victim was septicemia. So Lordship, kindly can and the only injury was found over the head victim. It is amazing and when the victim was dashed by the behind by a tracker moving at high speed, he sustained only on injury that flew over the head. Such injury might have been caused to the victim by means other than RTA. So victim died is appears from the PM report the septicemia. So Lordship, the observation of the learned tribunal, it may not be happen. It may not be happen by of accident. Lordship, I find out from the other source. I found the septicemia can be happened in any accident because of his open blood. So in maybe viral inspection, maybe happen. But Lordship, kindly see also the learned tribunal come to a conclusion. The eyewitness a second time has come before the tribunal. In first time they have also come. Lordship, I am placing the evidence on that score. Lordship, kindly come to the evidence. Police file charge sheet on FIR. Police file charges against the driver of the offending vehicle.
Which page?
Lordship, the eyewitness page. Lordship, kindly come to page 12. This is a chief and page 13. Lordship, kindly come. Lordship, kindly come to page 13.
Yes.
The cross-examination on behalf of the OP2. While Lordship, from the first line, I am deposing for the second time as witness in an accident. On this examination, learned tribunal found observation that this is a habit of to appear before the court of law as an eyewitness. But Lordship, is the second time is as a witness, but there is no questions put by the respondent what was his first time. So to clear the doubt, what was his first time, then question was arose that what for he has come further. But Lordship, kindly come to the first line of this page number 13, just after MSCC case number. Lordship, kindly see that. Further examination in chief. See Nandulan Bind SPW3 start today at 4th August 2018. So while Lordship, there further examination. What for further examination? There is no other examination. If in this case his first time is examined, but Lordship, kindly see the page 12. Why I don't know why the heading the statement has come from the learned tribunal. Lordship, in the page number 12, Lordship will found here's the file order 18 rule 4 affidavit in chief of page 12. Page 12, order 18 rule 4, the affidavit in chief, whereupon Lordship, kindly see there is the file by notary public, whereupon Lordship will found 16 July 2018. So on 16 July 2018, he has come to the court and signed. So that is the first time. And the same the cause of the affidavit in chief filed on, Lordship, kindly see the top of this page, filed on 4th August 2008. So first time he has come before the learned tribunal for any other purpose on 16 July 2018, and thereafter on 4th August. So in all other evidence, there is the 3 evidences there, owner and other eyewitness. But why the learned tribunal has recorded the further examination in chief, see Nandulan Bind. Why further examination? His usual examination, he filed the chief and faced the cross. But Lordship, on that score, I am deposing for the second time as a witness in an accident. On the score, learned will come to observation. There is observation from the judgment that is the habit of the to appear before the claim case as an eyewitness. But there is no question what was his first time. That question was not there. But Lordship knows that the section 154 of the Evidence Act, Lordship will found that the question by party to his own witness, the court may, in its discretion. So if court feels some doubt, court can also put the question. But I have filed the appeal against the observation of the learned tribunal. In its discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. But he's just put second time. He has said yes, second time. Because the first time he has come for affirmation of the affidavit in chief, and second time he has come for deposition. But even then, if there is a doubt, then he has to put the question, what was your first time? But they did not put this question before to the but under such observation, the learned tribunal come to observation, your claim case is dismissed. And accordingly, this was the employee of the Eastern Coalfield Limited. The evidence has come, someone has come from the employer and prove that is my employee and he is the we are paying the this is my employee, then is pay slips. The pay slip also been exhibited. And that exhibit copy also I am extract with. Accordingly, the learned tribunal also did not consider the pay slip also. Also, septimacia that I found from checkup that maybe happened by an accident. That maybe happened. Also, can check up and that is the I check up on online that I have checked up, but that can be happened on accident. But according to the learned tribunal also not consider the pay slip and other the calculation not made because of claim case dismissed on the two grounds. It appears from the postman page 24. Lordship kindly see page 24 the septimacia that what is there, and another is that the second time has come on this two score. Appeal can be should dismissed.
You have nothing to say?
Yes, page 39, my lord will kindly come to of the paper book. Third paragraph. Learned Tribunal disbelieved the case because it's a case of delayed lodging of FIR. This paragraph, my lord, the fact of the instant case are distinguishable from the facts before the honorable court. One judgment had been cited. So the facts of this case is different from that. In the instant case, on scrutiny of evidence on record, both oral and documentary, on closer scrutiny, it is found that the petitioners have failed to prove that the victim met with an accident on 10th of January 2014, sustained injury and died as a result of accidental injury at all. So this decision is also not applicable under the fact and circumstances of the present case. To sum up, from the evidence on record, the petitioners have not been able to prove that the victim met with an accident on 10th of January 2014 at 8:30 p.m. at Bogragram Moor, being dashed by the alleged offending vehicle due to rash and negligent driving by the driver of the offending vehicle, sustained injury and died as a result of thereof on 20th of January 2014. So this is the reason for dismissal. My lord will kindly fix up another date because this will take some time. This matter.
There is only two issues.
For further hearing, my lord will kindly.
For the submission of learned advocate representing the parties. Next date we fix on 6th of November.
My lord.
As-
Let's make it part hard lordship. Part hard lordship.
No.
Finally, November lordship, some problem will arise because after vacation, if it change, then I will not get touch with the lordship. Kindly make it part hard. One request.
Go before another bench.
No, lordship. Kindly make it part hard. Boli na me. Actor, kindly make it part hard. Part hard. Only this case part hard. I will not say anything, lordship. Make it part hard. Whatever will happen. I will face. So make it part hard, lordship.
Next.
My appeal, my lord. Mr. Approved appeared other day. I served him paper book. I served him paper book on that day. And this is my 163 appeal.
The learned advocate
If you lordship
representing
permit,
the
I can file the
appellant
paper book and
present, none appeared to represent the respondent. Number 1. Insurance
I am
company.
filing the paper book, let it be fixed for 4 orders. It will be disposed of. Only for enhancement on 163.
The learned register administration LOM is to instruct the concerned police station to serve notice upon the respondent insurance company intimating the next date of hearing for proper representation. Next date we fixed on 19th of September. Next.
$76, $77, $78, and I am for the appellant, my lord.
Mr. Ashik
Mondol
Mondol is appearing on behalf of the claimant's respondent. He's unwell. He called me up in the morning. He's suffering from fever.
He has also messaged me, my lord. I will adjourn it for a week or 2 weeks, my lord, as your lordship.
His fever will continue for 2 weeks.
As-
Tomorrow only I will file him properly.
No, he
he's not
requested me to. No, he is a little unwell. He was already running temperature probably. So he.
The learned advocate representing you for the
I am for the appellant insurance company.
Appellant Insurance Company is present. None appear to represent the appellant claimants. Next date we fixed on 14th of August.
Grateful,
Grateful, my
grateful,
lord.
lord.
Yes.
Mr. Mondol is appearing. Both Mondols, Shubhankar Mondol and Ashik Mondol. I am appearing on behalf of the respondent insurance company. Mr. Shubhankar Mondol requested me to pray for some time.
After November,
After November, my lord.
none appear to represent the appellant claimant as well as respondent number.
I'm appearing on behalf of one.
Respondent number 1, the learned advocate representing respondent number
One. Oh, I'm sorry. I'm sorry.
Who are you?
I'm respondent number 1, insurance company.
Who is Mr. The other Mondol?
Ashik Mondol is for the appellant. Shubhankar Mondol and Ashik Mondol, they are for the appellant. They are on record. Shubhankar Mondol is on record.
No, but then you said there is a different another insurance company.
No, not this one.
The respondent number 1 is present. Next date we fix on 20th of November.
My lord. 20.
His situation is improving. Next.
My lord, I am for the respondent. I am for the appellant, my lord. This is an injury case, my lord, under section 166 of the Motor Vehicles Act. My lord, dispute is income and disablement certificate of Binod Das.
Percentage of disablement?
30%.
Hmm?
30%.
What had happened?
My lord, only some injury, minor injury.
Minor injury? What is the injury? Still, the minor injury. Minor injuries.
Why have you come?
Income and
You've just come for the sake of coming.
my lord, award is
Only on the amount of the compensation. Ashwin,
My lord, I have to say something, my lord. My lord,
have you filed cross objection?
no.
At the submission of learned advocates representing both the parties. Next date be fixed on 24th of September for orders. Next.
Your Lordship, I am
Instructions to appear for respondent number 1 by the High Court Legal Service Committee.
Your Lordship, I am appearing for respondent number 2. We haven't received any paper book yet.
I have just received the paper book from my learned.
Yeah, they're all, I am having the paper book, they're not here, the second, sir.
Your Lordship, we will receive the paper book from my learned senior tomorrow kindly, because today no one is present in the court.
The learned advocate representing the Appellate Insurance Company has filed the paper book. Let the same be kept on record.
I'm for the respondent number 1, claimant.
The learned advocate.
I've been appointed by High Court Legal
Such and
Service.
such has been appointed by the High Court Legal
High Court Legal
Services
Service.
Authority.
I am from
to
respondent number 2, car owner, my lord.
Respondent number 1, claimant.
Respondent number.
And another. Respondent number 1.
Respondent number 1, claimant. Now tell me what is it?
Your Lordship, this appeal should be dismissed today itself. No, not, Your Lordship, that it should be dismissed on the ground the total quantum is not above 1 lakh. It should be 1 lakh, then only it's maintainable. Appeal is maintainable before this Honorable High Court. So this should be dismissed, Your Lordship. I find out right now when the paper book, I was going through the paper book, it should be dismissed. But my submission shouldn't be from the appellant.
So I'll fix it for orders.
Yes, Your Lordship, it could be disposed of anytime.
Next date be fixed on 11th of August for orders. Next.
11th August.
87, my lord, I am appearing for the respondent claimant.
I'm appearing on behalf of the Appellate Insurance Company.
Today, my lord, I am filing the paper, my lord. This is a case, death of a bachelor, my lord. Purely quantum.
I've taken the ground of this FIR implantation, my lord. That is also there. Then interest is also.
Implantation.
Huh?
FIR implantation?
No. I've taken the ground of implantation. I'm sorry.
Only the one.
This is one, then interest is there, income is there. These are my only 3 grounds.
Coverage.
Paper book filed by the learned advocate representing the respondent claimants be kept on record. Did you file any cross objection?
No.
Yes, madam. Can it be disposed of?
It will take some time. My lord will kindly fix it for further hearing if it can be disposed of on that day.
No. You are saying implantation?
Yes, implantation and quantum.
Implantation.
Honestly speaking, I'm not ready in the matter.
So say that. Next date be fixed on 19th of September.
My lord.
Next.
Yes, my lord. In this case, I am
90. This can be disposed of.
Yes.
This is my
Challan,
my lord.
Yesterday,
I've deposited. I've taken the ground of.
Today, my lord, I am filing the paper book.
I've
On the stay to be made
absolute, my lord.
Stay absolute. But
this can be disposed of.
in a paper book
I have received.
filed by the learned advocate representing the respondent claimants, serving a copy of the same upon the learned advocate representing the Appellate Insurance Company. We kept on record. Why have you filed?
Implantation, but this can be disposed of.
Initially, my lord, vehicle was unknown. Initially, in the FIR, vehicle was unknown, but subsequently, my lord, charge sheet has
She
been...
can't go beyond the charge sheet. (23rd of September for orders.
My lord. Grateful, my lord.
92.
Madam, I am for the appellant. It's a railway underwood case where the matter was fixed for hearing. So I am ready with my written argument. Yeah.
My lord, I appear for the respondent, railway, my lord.
I am filing the written
And,
argument.
my lord, your lordship called for the, my lord, record from of tribunal, my lord. No exhibited documents, my lord, was available in the record, my lord. And, my lord, the accident has not been proved. My lord, the investigation report is not there. That
So have you you have the records with you? No.
my lord, I have not looked at, my lord. That the
রেকর্ডটা তো
And Your Honor, I will argue orally. Your Honor, I have a lot to say.
আছে the TCR call for হয়েছিল হ্যাঁ TCR is there. If you want, you can obtain the copy of the exhibits therefrom.
TCR was called last time. So
my lord,
TCR
can I look at, my lord, that
No, whether you want to inspect or you want to obtain the copy of the exhibits.
inspection will sufficient, my lord.
Today it was fixed for hearing, my lord. I was ready for hearing.
So he wants to inspect, and if he doesn't have the copy,
No, I don't have
let him go through it once and thereafter. The learned advocate representing the respondent railways.
Respondent railway.
Seeks leave of this court to inspect the trial court records, and the same is allowed. The court clerk is to assist the learned advocate representing the respondent railways to inspect the trial court records after the court hours on 18th of August.
Let it be.
Next date be fixed on 19th of August.
As you wish.
Next.
देखिए
Not a vector for the appellant, my lord. My lord, we have paid the statutory deposit, my lord. This is the receipt. It's an MACC appeal of 24, my lord. There are two applications, one stay and one section 5. One is the section 5 application. There's a delay of 291 days.
Where is your other side? Have you served notice?
But for the first time, my lord. First time. Section 5 has not.
Ashun. 466 days. Hey, Srimanta. তো কিছু হয়নি Three, four, five, six. You deposit the remaining amount. What is the entire amount of compensation? You are representing which insurance company?
The insurance company. The owner of the vehicle.
The liability was cast upon you.
Was that
So how can you differentiate yourself with that of the insurance company? Deposit the entire sum and then come. 4 weeks issue notice. File affidavit of service. Which is a district? Purulia. 24th of September. Next.
This is the appeal of claimant for enhancement of the awarded sum. It's not only confined to the quantum.
Paper book has been filed.
Paper book has filed today, madam. Learned tribunal not granted 6% interest instead of.
Paper book filed by the learned advocate representing the appellant claimants. You have received a copy? We kept on record. A copy of the same has been served upon the learned advocate representing the respondent insurance company. Only the interest. Next date be fixed on 12th of August for orders. Next.
Same.
98 is same, madam.
Same order. Next.
I filed the paper book. 98.
Next.
98.
101.
My lord, I am for the appeal in this case. This case, my lord, everything was completed and it was for order. My lord, on last occasion, you honor told that railway has no difference as because ticket and fall both are admitted by them. So this was the case.
Your Lordship, I have already filed the written argument in this matter. On the last occasion, thereafter it was for the order, the same thing. Again, it has came for the hearing. There are something.
The record could not be traced out or something, it happens. Anyway, hearing concluded, CAV. Next.
Matter.
103.
Because I am not last occasion I have filed.
Well, Mr. Paul appears for New India.
I don't know.
Who is there in this matter?
103.
Who is appearing for the insurance company?
Lord, I'll see till somebody appears, Lord, on next day. Somebody must have been appointed, Lord. I do not know why the person is not. Take it up, Lord, on Monday, Lord, somebody would appear. Want to বলেছিলাম না কি appear করছে?
Yes, sir. The learned advocate representing the appellant claimant is present. None appear to represent the respondent number 1 insurance company. Mr. Singh, can you inform them or else I'll ask the
Lordship, it came down Monday or any day thereafter, Lord, somebody would appear.
next date be fixed on 11th of August.
Lordship. Let put him on.
My lord, I am appearing on the respondent claimant. Mr. Guddu Singh is appearing in this case. My lord, today I am, as per your lordship's direction, today I am filing the paper book.
None appear to represent the appellant insurance company. The learned advocate representing the appellant claimant has filed the paper book. Yes, start the matter. Are you the advocate on record?
He is appearing on behalf of the owner of the vehicle.
Then why is she standing there? Has she filed the response? She has been asked by Mr. Guddu on record. Sorry. Next date. Now, what is the matter, sir?
My lord, insurance company has raised the issue for fake DL, my lord. The DL is fake.
Next date. be fixed on 10th of November.
My lord. 10th of-
He only appears for getting the stay order.
I have already, my lord, served copy.
Once the stay is obtained, thereafter for hearing, he seldom appears.
I have already served, my lord, copy of the paper book.
My lord, in item number 104, I'm there, my lord.
Like the paper book, let the same be kept on record. Next.
Milord, 109 is claimant's appeal. This appeal, Milord, was dismissed against the insurance company and the owner was made liable to pay on the ground that the offending vehicle did not have an insurance policy. Milord, the insurance policy, Milord, as far as the lower court record is concerned, Milord, it shows that it was seized. But Milord, only the seizure reference is there, nothing more is there. London Tribunal Judge specifically recorded that there are no documents with relation to the insurance policy, so I'm not going to accept. Milord, in this case, Milord, my learned friend has filed an application before your lordship. Milord, wherein, Milord, prayer has can 2, Milord, perhaps it is there.
Can 2 is for what?
Milord, for with the prayer before your lordship, Milord, to call for the Milord those police station, Milord, the records wherein, Milord, in the seizure list and in the charge sheet, Milord, the policy, they say the policy was seized. But Milord,
He has filed his day before it. Yesterday, it's not on record.
tomorrow can I take it up on Monday, Milord? Oh, sorry, Monday can no. Milord, whenever, Milord, Thursday, Friday, whenever.
The
आज को मंगलवार ना
learned advocate
can
representing
to आशे नहीं है.
appellant claimant submitted to have filed an application being what? What is the
Milord,
number?
can 2, Milord, of 2025.
2 of 2025. The department is directed to place a case record of the aforesaid CAN application along with that of the main appeal on the next date of hearing. Next date be fixed on 3rd of September.
3rd of September. Grateful to your lordship.
Next.
On that score, almost a weakness, they are the charged weakness as called for by the insurance company. They make hostile to the learned tribunal. So lordship kindly fix the matter any paperwork that I have filed and I also served.
What? Dismissed the matter?
It was dismissed.
Yeah,
On
application
that score,
dismissed.
The she witness, they are the charged witness. Has come before the learned tribunal and deposed that they don't know about that accident. So according to learned tribunal, relying upon their evidence, dismiss the claim of the article. So my humble submission is that
Eyewitness denied.
not eyewitness.
Yes, yes, charged witness, but there's no eyewitness.
No, lordship, not eyewitness. That the statement, the under 61 statement that's collected by the police. That under 160 statement, that statement given by these 3 persons. And the 3 persons on the as a OPW witness, they have come before the learned tribunal and they are also hostile against the submission against the prosecution. So my humble submission is
The records of the criminal proceedings the records of the criminal proceedings were placed before the tribunal.
Before what? Before the criminal proceeding not placed with the tribunal.
Then how can you say they turned hostile?
Because of before the learned tribunal they are hostile.
Before the learned tribunal they were hostile.
They are hostile. And lordship, the driver still abscond. Driver of the opinion is still abscond. And charge sheet file is against the abscond driver. So criminal proceeding is still pending. My humble submission is the hostile witness, the hostile that were not in the evidence. It is the vocabulary that is the hostile because of I have placed 2 judgments. One judgment lordship's award, the judgment Calcutta High Court judgment that is 1931 Supreme Court, Calcutta High Court, the Profullo Kumar. And next lordship the judgment of 2025. By considering the Calcutta High Court judgment, the Supreme Court delivered the judgment. With the judge, the witness hostile, they are not supporting the evidence of the prosecution, so that the witness cannot be relied upon. So if there is enough evidence produced by the prosecution. So lordship kindly, I have brought these 2 judgments on that score. Lordship kindly
No, whatever you said, it goes against you.
I am not Lordship, I am not. The witness has come before the learned tribunal. Their deposition against me, against the claims.
Okay, you give those decisions. You have copies? Give it.
May I just the case? May I submit this?
Next state. For the submission of learned advocates representing the petitioner, the learned advocate representing the respondent as a petitioner, to have a appellant claimant. The learned advocate representing the respondent insurance company is present. Next date be fixed on 21st of August for further hearing. On that date, you place your case. Next.
Not in this appeal of insurance company, the statutory amount has not been deposited as a collectible sometime.
Which was the last date given to you?
Not the certified copy of award was also, it was filed with the true copy. Thereafter, I obtained the certificate.
The defects were not removed.
The defects were not removed in the sense, the certified copy was not available and the statutory amount was not paid. But subsequently, I got the certified copy. Certified copy has been filed, but the statutory amount has not been deposited.
When did you file the certified copy?
17th of June 2025. Initially, it was filed with the true copy in the month of May 2025.
Within how many days will you file?
10 days.
The learned advocate representing the appellant insurance company is to file the statutory amount by 13th of August.
For respondent number
Respondent number?
1 and 2 and also cross objectors.
10 days below them.
Ninth, 19th of August. Length said be fixed on 19th of August. Next.
March of this.
Of the appellant insurance company, there are two insurance companies. One is United. Mr. Singh is appearing on behalf of United. And this is purely on quantum, my lord.
Now,
I am for the
cured.
My lord.
I can find a noting over here. It states defective out of time. So
no, my stay has already been made absolute on 2nd of May 2025.
yes, my lord. I am for the respondent number 1.
who has filed paper book?
The paper book, no, the paper book I'll be applying for the certified copies. If the TCR has already come, then I shall be applying for the
learned advocate representing the appellant insurance company is to obtain the certified copies from the department upon compliance of requisite formalities and prepare the paper book to be submitted on the next date of hearing. Next date be fixed on 6th of November.
My lord.
My lord, I am for the respondent number 1.
The learned advocate representing respondent number
1 to 6, my lord.
1 to 6. And Mr. Singh, you are?
Respondent number.
He's I'm giving the number.
Respondent claimants as well as the.
He's 8.
You are from 1 to 7.
1 to 6.
1 to 6.
1 to 6. And respondent number 8 are present. Next.
Grateful, my lord.
120, I am for the respondent.
I saw Mr. Ganguly, Shomallo Ganguly somewhere here. Where is he? He was there.
Respondent 1 to 6.
Two Gangulis. এটা আছো তো?
Your stay had been
I've
made absolute.
Yes.
Now, what is you are appearing for the first time?
Yes, ma'am. I have filed my VOCA only.
Now, who will prepare the paper book?
I will prepare the paperwork, Your Lordship.
The learned advocate representing the appellant insurance company is to file the paper book on the next date of hearing. The learned advocate representing respondent claimants.
Yes, ma'am. 1 to 4.
1 to 4 is present. You require the TCR?
Yes, Your Lordship. Yes. Let us say certified copy আমি obtain করতে পারবো তো। Your Lordship kindly TCR
কি করে পাবে certified copy?
এই যাবে এখান থেকে obtain করে নেবো।
How can he obtain the certified copy of which? What?
Paper needs to be filed from the certified copy, no, of the whole record.
You are appearing for the first time in an FAPK matter?
No, no, my lord. He is asking for preparation of. He wants to get a certified copy of what?
TCR, trial court records.
Yes, that is the LCR, my lord.
It has to be called for.
Yes, my lord is calling for that. My lord, now he says.
And he will apply in the department. Ache. Then you obtain the certified copy.
A leave to be given then, a leave.
The department is directed to serve copy of the trial court records upon the learned advocate representing the appellant insurance company on complying requisite formalities for preparation of paper book. Prior to the next date of hearing, next date be fixed on 7th of November. Next. 123, 124.
123 is my appeal. 124 is my learned friend's cross objection. My lord, in this matter, I've received the paper book from he has prepared the paper book. My lord will also grant me leave to prepare one supplementary paper book. I'll annex my additional written statement in that. It's not part of the paper book.
The learned advocate representing the appellant insurance company seeks permission of this court to file the supplementary paper book and the same is allowed. The paper book has already been
Yes, yes,
here.
yes. Today he filed it.
The learned advocate representing the respondent claimants has filed the paper book. Let the same be kept on record. Next date be fixed on 10th of November.
My lord, grateful, my lord.
125.
Insurance company affiliate, my lord. In the matter, Mr. Asik Mondo on behalf of the claimant respondent is suffering from fever, my lord.
The learned advocate representing the appellant insurance company is present. None appear to represent the respondent claimants. Next date be fixed on 26th of August.
26 August.
Next.
This is my appeal. This matter has already been fixed for orders on 31st of July 2025 by an order dated 6/5/2025.
Why is it appearing in this list? The correction এর জন্য আছে নাকি?
By 5/25 অর্ডারটা।
There's a lapse on the part of the department.
Also, kindly fix it any other date.
Next, the learned advocate representing both the parties are present. Next date be fixed on 3rd of September.
Deeply understood.
I'm appearing on behalf of the appellant insurance company, my lord.
Paper book already filed.
I have preferred this appeal mainly on the point of quantum and contributory negligence of the victim. What happened? Victim was driving a car, and it's the case of the claimants that a lorry overtook the car of the victim, and as a result, victim's car went and dashed one stationary vehicle. So my case is that there was contributory negligence on the part of the victim because a total of 3 numbers of persons expired because of the accident. This is one ground, and the other is income tax was not deducted from the salary of the victim. He was posted at Raghunathpur. He was a manager of Larsen and Toubro, and he was posted at Raghunathpur Project Purulia. But the
next point?
these are the mainly 2 points. But this will take a little bit of time because regarding this contributory negligence, my lord, I'll give some judgments. So this will take a
To bring the judgments on the next.
My lord.
130 from 130
Same, my lord.
30 to 133. These 4 are all those they arise out of the
Same
self-same accident.
One is death of
131, 132, 133.
3.
So, there has been a collision.
My lord, yes. They arise out of the self-same accident.
Self-same accident.
One is for the husband,
In
and
each and every matter, you are pleading contributory negligence.
in all these, yes.
what I'm
My lord.
At the submission of learned advocates. Why have you filed a cross objection?
Well, for enhancement, my lord, future prospect and others.
Heard the submission of learned advocates representing both the parties. Next date we fixed on 25th of September for orders.
It takes some time, my lord. My lord will let me argue this case at least. Kindly. For further hearing.
When did you file it? This year?
24.
24.
24, last year.
For further hearing.
Grateful, my lord. Grateful.
25th September.
Grateful, my lord.
134.
134, kindly make it not today, my lord. My lord, I sent, my lord, 134, but your lordship granted, my lord, intense stay, my lord. I sent, my lord, copy of memo of appeal upon the respondent. If it is service not ready, my lord. Kindly.
What about your stay application?
Stay application, my lord, I have my lord, already.
You have not issued the notice.
Yes, my lord. Notice issued, but evidence service not ready, my lord. Service not ready.
It was delivered.
Not delivered, my lord. In fact, I have not checked that accident. I'm sorry, my lord.
On the prayer of learned advocate representing the Appellate Insurance Company, the matter be fixed on 28th of August 20.
Well, grateful to you. Grateful.
My lord, I'm for the Appellate Insurance Company. My lord, the stay has to be made absolute. And I have all the certified copies, my lord. I can prepare the paper book, and the advocate for the respondent has already filed his wakalatnama today. He came to here, but he left in order the
State absolute. Where's your affidavit of service?
It's already appeared, my
Who has appeared?
lord.
What is his name?
Gopal Chandra Singh. He is the advocate in the tribunal also. He has come here. He has
Did he
filed
appear before this court?
My lord, he has filed his wakalatnama today.
Today? And thereafter left?
My lord, this appeal can be quantum and contribution.
None appear to represent the respondent claimants. Let the matter be adjourned for the day. Ask him to appear tomorrow, then I'll fix it for orders.
I'm grateful.
State absolute, huh?
That's good.
You are not.
You know what?
Shameful, no.
Yes.
My lord, 137 is insurance appeal pursuant to my lord's earlier direction, my lord. The awarded sum has been deposited and it has been served, my lord. May I file my affidavit of service as well as, my lord, the deposit challan, my lord. My lordship will kindly make this stay absolute. My learned friend is appearing on behalf of the claimant, my lord. He is filing the paperwork, my lord, today.
State absolute. Where's your affidavit of service, or did he appear earlier?
No, my lord, for the first time, my lord, it is appearing.
No, he has appeared earlier, or he's
No,
Yes, Lord. No.
He's appearing for the first time today.
I filed
But I made the service. He got the service, my lord, and he has prepared the paperwork in the meantime.
And what about your affidavit of service?
Lord, I have filed.
Filed?
Yes.
Acha. Affidavit of service filed by the learned advocate representing the Appellate Insurance Company be kept on record. Now, who has filed the paper book?
I have already filed the, today I filed the paper book.
Paper book filed by the learned advocate representing the respondent claimant be kept on record. Now, what is it?
Lordship is the quantum is basically the issue. Quantum is basically the issue.
He has filed the appeal.
Yes, I have prepared the paper because I've gone through the enough all papers. We are not with the all papers.
So you know his point of appeal.
Because
Since
of-
you have prepared the paper
Because
book.
of the memorandum of appeal supplied to me for preparation of paper book. Wherefrom I know.
That is true. But he has
That is
not.
true, and lordship of all the paper, the certificate copy with me, that is not with Mr. Singh. That's why you don't know what is the case about that. So only paper and appeal is the same ground as for all appeal. And the point involved in this appeal is the basically quantum. I believe Mr. Singh will affirm that there is the basically quantum because of the wife has got the service and got the compensation appointment. This is the one of the ground of the appeal. One of the ground of the appeal.
One ground. Lord, I have taken 14.
14 grounds.
So lordship, there is the only the sole appeal lordship will have had. Maybe a 14 ground add in law, but the only ground is that there is the compensation appointment. For the reason the lordship, the law will be decided.
What is it?
My lord, it's a case of composite negligence.
So it seems there needs to be a hearing.
Composite
Acha.
negligence, there is no evidence.
Next,
Lordship, there is no evidence support of them. Only the
fixed
plea
on
is there.
7th of November for further hearing. Next.
নভেম্বরে কোনো মামলাই হবে না নভেম্বর মানে আমার কোনো
And he's November, there will not be any.
For November, those would be automatically get adjourned, my lord, after November in view of this submission of my learned friend. তোমার কথা হলো
Next.
7ই November.
Lordship, I appear for the claimant appellant, Lordship. Today I filed. What matters is, Lordship, quantum point. Only future prospect and low interest income, Lordship.
Income, future prospect, and interest. 8,000 rupees was granted. They are asking for more, my lord. The victim was a quack doctor. Or if I call him a doctor at all, he was a quack. And my lord, the future prospect not granted. 8,000 rupees per month was considered.
Has she filed the paper book today?
Today.
Paper book filed by the learned advocate representing the appellant claimants be kept on record. A copy of the same has been served upon the learned advocate representing the respondent insurance company. Next date be fixed on 7th of November for orders.
7th of November.
My lord, I am for the appellant insurance company. In terms of your lordship order, we have deposited the entire amount and also affidavit of service is there. My lord, also
Affidavit of service filed by the learned advocate representing the appellant insurance company be kept on record. State absolute.
Lordship, I am for respondent number 1.
Have you filed the wakalat number?
Lordship, yesterday.
What is your name?
Momita Ganguly, advocate.
The learned advocate, namely such and such, submitted to have filed the wakalatnama in the department to represent the respondent claimants.
Respondent claimant number 1.
Number 1. So you will file the paper book? The learned advocate representing the appellant insurance company intends to file the paper book and the same is allowed. Next date be fixed on 10th of November.
Lordship.
Next. 140, I am appearing on behalf of the appellant insurance company. This is my
file the paper.
This is my affidavit of service, my lord. I have deposited the entire awarded sum before my lord's court.
Just state absolute. The learned advocate representing the respondent claimants has filed the paper book. Let the same be kept on record. What is this Can 1 2025 disposed of?
The stay.
Stay, okay. What else? Anything else?
We filed a court objection. Court number is 106 of 2025.
The learned advocate representing the respondent claimant submitted to have filed a cross objection being such and such. Give the number in a slip. The department is directed to place a case record of the aforesaid cross objection along with that of the main appeal on the next date of hearing. Next date be fixed on 10th of November. My lord.
We filed the paper book today.
Paper book to be kept on record. Next.
The next matter, my lord, it's affidavit of service to executive. My lord, I have deposited the entire awarded sum before my lord's court.
You want the stay to be made absolute?
My lord, my lord.
State absolute. Who is appearing for?
No, nobody.
Nobody. Affidavit of service filed by the learned advocate representing the Appellate insurance company. We kept on record. It was served.
It is 141.
141, I am appearing on your.
Oh, 141. When I asked you, you were roaming around.
No.
Sorry.
Now, what about paper book?
Paper book I shall prepare and file
The
with them
learned
on
advocate
the next day.
representing the respondent claimants intends to file the paper book and the same is allowed. Next date we fix on.
We have preferred one cross objection, my lord.
Acha, the learned advocate representing the respondent claimant submitted to have filed a cross objection being such and such. The department is directed to place records of the aforesaid cross objection along with the main appeal on the next set of hearing. Next date be fixed on 11th of November.
11th of November.
Yes. Next.
The next matter is similar, my lord. I have deposited the entire award.
Mr. Mondal, are you there in 142?
No. Okay. I've deposited, my lord. This is my affidavit of service.
Affidavit of service, it was 142. Affidavit of service filed by the learned advocate representing the Appellate insurance company. We kept on record. Chalan, you have given?
I'm giving, my lord. I've deposited the entire awarded sum before my lord's court, my lord. Chalan got. I'll give the photocopy in course of the day, my lord. I'm giving.
Date to be made absolute. Despite service of notice, none appeared to represent the respondent claimants by registered administration or auditor. Next date, 12th of November.
My lord, grateful, my lord.
Next.
It got mixed with the other matter.
Next.
This is insurance company's appeal. I have already served upon the opposite party and deposited the entire award. It's
the same order. 13th of November. Next date. Next.
Next is also insurance company's appeal. I have already deposited the awarded sum and the affidavit of service.
144 same order. 14th of November.
Both the cases that stay application is there.
I have mentioned your stay should be made absolute. Next, 145, 146.
145, Lordship, I apply for the claimant respondent, appellant, Lordship. I paying for Lordship some sick accommodation, Lordship. Paperwork is not ready. So only 2 weeks.
The prayer of the learned advocate representing the appellant appellant claimants. Let the matter be fixed on 12th of November. For filing paper book, learned advocate representing the respondent insurance company is present. Next.
My lord, in item number 146, I am appearing for the respondent, Phoenix Overseas.
145, Chilo. 146.
My lord, in item 146, I am appearing for the respondent, Phoenix Overseas. I am being led by Mr. Bhaskar Roy and praying for 2 weeks adjournment as he is out of station.
Ricotta. And appeared to represent the Appellant Union of India. The defect directed to be removed by order dated 7/9/2022 passed by this court has not been complied with. Let the matter go out of the list. Next.
My lord, I am for the Appellate Insurance Company. In terms of your lordship order, we have already deposited the entire amount and also affidavit of service and follow up. My lord, one leave may be granted, my lord, because here typographical error is there. Respondent number, instead of 3, we have written 2. Just 2. 2 to be recorded as 3. That's all.
The learned advocate representing the Appellant Insurance Company has filed the affidavit of service. Let the same be kept on record. Challan you have given, sir.
Yes, my lord.
Stay to be made absolute. Where you have mentioned?
My lord, in the memo of appeal.
The learned advocate representing the Appellant Insurance Company further stated that the respondent number 2.
This already 1, 2, 2, but 1, 2, 3, it will be 3.
Respondent number 3 had been wrongly
Mentioned as
typed
2.
as respondent number 2 in the memo of appeal. Leave is granted to rectify the same.
Lordship, I'm grateful.
Despite service of notice, none appeared to represent the respondent claimants. Administration auditor दिए. Next date we fixed on 11th of November.
Lordship.
Next.
Milord, 148 is insurance appeal, Milord. Pursuant to your lordship's earlier direction, Milord, the awarded sum has been secured before my lord's court, Milord. I have also. May I file my affidavit of service, Milord?
Affidavit of service filed by the learned advocate representing the Appellant Insurance Company be kept on record. You want the state to be made absolute?
My lord, my lord.
You have given the copy of the challan?
Yes.
State to be made absolute. Despite service of notice, none appear to represent the respondent claimants. The ये order to दिए. जाओ जाओ बताओ तुमको कौन भेजा? Oh, on 14th of November.
Oh, bless your lordship.
Next.
My appeal, stay needs to be made absolute. I'm filing the challan copy.
You were there earlier, or did they appear on the earlier occasion?
Yes, they appeared on that.
The learned advocate representing respective parties are present. The stay absolute.
I filed the paper book
The
today.
paper book filed by the learned advocate representing the respondent claimants, serving a copy of the same upon the learned advocate representing the Appellant Insurance Company be kept on record.
We filed a court objection.
The learned advocate representing the respondent claimant submitted to have filed a cross objection being numbered
Court 118 of 2025.
Court 118 of 2025. The department is directed to place the case record of the aforesaid cross objection along with that of the main appeal on the next date of hearing. Next date we fixed on 12th of November. 151.
I'm appearing, my lord. This is my affidavit of service. I've already deposited the entire awarded sum before my lord's court. Mr. Rahman is appearing on behalf of the.
Who will file the paper book?
I shall file.
Affidavit of service filed by the learned advocate representing the appellant insurance company be kept on record. State absolute. The learned advocate representing the respondent claimants intends to file the paperwork and the same is allowed. Next date be fixed on 14th of November. My lord. Next.
Same, my lord. Mr. Mondol is appearing in this matter. I have deposited.
Mr. Mondol is filing the paper book or will file?
He will.
Same order. 14th of November.
My lord. Deeply obliged, my lord.
Lordship, the stay needs to be made absolute. And there's an affidavit of service as well. Affidavit of service.
State absolute. Affidavit of service filed by the learned advocate representing the appellant insurance company be kept on record. It was delivered.
Delivered. Delivered. Yes, your lordship.
Order to correct.
Delivered, your lordship.
Despite service of notice. 17th of November, next date.
Lordship, stay needs to be made absolute. Affidavit of service.
The same order. 17th of November. Next.
My lord, I am for the respondent, my lord. Rest of the amount deposited, my lord, channel.
Stay to be made absolute. Have you filed the wakalatnama?
Yes, my lord. Today I have
filed the paper book.
I shall file.
The learned advocate representing the respondent claimants submits to have filed the wakalatnama in the department. The learned advocate representing the appellant insurance company intends to file the paperwork and the same is allowed. Next date we fix on 18th of November. Next.
I'm for the appellant insurance company. Well, a stay needs to be made absolute, and he has already filed the paper book, prepared the paper book.
State absolute. Who will file the paper book?
I'll already prepare. I'm filing the paper.
Paper book filed by the learned advocate representing the respondent claimants be kept on record. Next date be fixed on.
With 163A, lordship.
My lord, this cannot be disposed of just like that, my lord, because this is a murder case, my lord. I'll have to explain.
11th of November for further hearing.
I'm grateful, my lord.
Next.
Not 157. Milord is the insurer's appeal and along with the cross objection filed by my learned friend on behalf of the claimant. Milord, on the last date, paperbook aage file hoye chilo. Milord, paperbook was already filed before your lordship.
Lordship also heard the matter.
Milord, it was mainly on the point of Milord a non-involvement. The first information report of the written complaint for the first time wherein the vehicle was Milord shown to be involved was 16 days after the date of accident. There was no driving license. And Milord, there was no post-mortem report as well in the accidental death case, Milord. So I have been doubted, Milord, the involvement of the vehicle as well as the accidental death of the victim arising out of the said vehicle. And Milord, the driving license was not there.
Can it be fixed for orders?
Milord, it can be fixed for orders, Milord, it can.
But the submission of learned advocates representing both the parties. Next date be fixed on.
It was fixed on 17th July, lordship, orders. Prior to that, on 17th July 25, it was fixed for orders.
It was fixed for orders?
Yes, lordship. 17th July.
Then how come it is appearing here?
Some of lordship on that lordship are called on the matter as well accordingly. But I don't know.
Second of September for orders.
I believe lordship.
My appeal for enhancement of the award. But 163A claim. Like driver received injuries.
The submission of learned advocates representing both the parties. Next date we fixed on 25th of September for orders.
Paper book file.
Paper book filed by the learned advocate representing the appellant claimants be kept on record. Next.
Insurance company, Mr. Rohman is on behalf of the entire amount handled.
State absolute. Who will file the paper book?
Well, I shall file.
The learned advocate representing the respondent claimants intends to file the paper book and the same is allowed. Next date be fixed on 13th of November.
161, my lord, I am appearing on the respondent claimant. As per your lordship's direction, I am filing the paper book today.
Your stay had been made absolute?
Stay has been made absolute.
Paper book filed by the learned advocates.
63A, my lord.
Paper book filed by the learned advocate representing the respondent claimants be kept on record. Next date be fixed on 7th of November for orders. Next. 162.
Your lordship, I am for respondent number 1, 2, and 3.
Filing for the appellant, I am filing the paper book today, Your Lordship.
Learned advocate representing the appellant insurance company has filed the
Payment.
paper book, serving the copy of the same upon the learned advocate representing the respondent claimants be kept on record. Yes, why have you filed?
Your Lordship, the main counts of appeal are
Let the matter be fixed on 17th of November for further hearing.
Your Lordship, this is only the on interest point. 7.5% has been given. That should be 6%. Sorry.
Ashun. When did I fix your matters that interest matter I had? Huh?
Lord, it is appearing in the list today, my lord, as item number 171.
I had
Interest matter
fixed a date where you said that it's only for the reduction of interest.
হ্যাঁ সেটাই তো
আমাদের যেটা 1998
my lord, today is item 1, that matter is appearing today's list, item 171. That's what I said.
97, 90.
Today I had fixed.
Yes, my lord. Only interest on
Oh,
12th,
data.
12th
Oh.
Which is
My lord, that is
1998.
not on 12th of September, 12th of
12th
August, 12th of August. Today, my lord, is fixed that. Yes, yes.
ওটা কেটে দিন লাস্টের ডেটটা কেটে দিই ওই না ওটা কেটে দিন নেক্সট ডেট বি ফিক্সড অন 13th of August for orders.
Deeply.
আচ্ছা এনি আর কিছু পেন্ডিং আছে যা আছে ডেকে দাও at least this list could be regularized for
My lord, will be not taking our orders. Not let it be roll over for tomorrow.
no at least one part has been made
Yes, yes,
regularized.
Yes,
This
the
part
entire-
could
entire-
if not for that
57, my lord, I am appealing for the petition. My lord, I am filing my reply.
who is your other side?
My lord, my learned friend,
আচ্ছা,
senior,
এইটা-
my lord, who is a
এটা না ডিসমিস ফর ডিফল্ট না করে এই একটাতে হ্যাঁ on the হয়েছে Was there in the list?
No, my lord.
No.
This was not.
One Miss Indrani Chakraborty, she's having knee surgery. She's appearing on behalf of Union of India in this matter.
In reply filed by the learned advocate representing the petitioner be kept on record. You had to file an affidavit of service. You were asked to serve notice.
My lord, I served notice. My learned friend, senior, my lord, appearing. My lord, Indrani.
Indrani Chakraborty. She's undergoing knee surgery.
From which date?
From which date? কবে হচ্ছে knee surgery? When is the knee surgery?
Knee surgery is not fixed yet and it is
It is supposed to take place on 14th of August, the knee surgery. She's going through all the process before the surgery.
None appeared to represent. Is it Union of India or the state?
Union of India. Union of India.
The respondent Union of India. Next date be fixed on 14th of November.
My lord. Grateful, my lord.
14th of November.
Grateful, my lord.
Grateful, my lord.
RSF. No, ওটা ছেড়ে দিন। Assign কি ওটা? না, ওটা ডিগ্রি না একটু। না, আর আছে না দুটো রিট আছে তো। না। একটা 200টা none appeared to
Ladyship, Mr. Mukherjee has requested me to kindly take it up after a week.
Sir, I was very disappointed.
I heard that, which is why I came.
Conduct It's a CBI matter.
Yes, yes, Lordship. Lordship, affidavit, opposition, reply, everything has been done. Mr. Mukherjee yet to submit before you. Here,
He seems to have joined Mr. Mukherjee's chamber. No, I'm talking about him because I have not seen him earlier. None appear to represent. You are not no way connected. You are there in this matter. On the prayer of the learned advocate representing the petitioner, let the matter be fixed on 17th of November. Pardon. Kumar has to be inserted in the writ petition. No, in the memorandum. আরে বাবা এরকম হয় না ওটা
Only that what can be.
কি বলছে কোন
গল্পটা তো আমি ভুলে
হুম
যাচ্ছি 17 সোমবার November, sorry.
that we'll take up at the time of passing orders. You just remind me. Has it been fixed for orders? So that time you remind me. Further hearing, ঠিক আছে. That time you remind me. Oh, is he the no adjourn for the day? Let him come tomorrow. Entire 1 hour was he was reluctant to take orders, it seems. Been cleared out. Yes. 75, huh? 75. 75 of your money. So that would have been regular. Okay.